execution cases, JD Pharmaceutical.
Lordship.
Pass the order, but I have added one line out there to the effect that this order be placed before the executing court. I have closed it, stated it is duly satisfied, but it has to be placed before the executing court so that the executing court closes the money execution.
My lord, we will do that. Yeah.
So that I have directed it.
My lord.
Because otherwise, what will happen? Those money execution cases will keep on going on.
Lord.
Although this court has closed.
Lord. God bless.
Yes, ma'am.
Item number 38, sir. Both the parties are advocates from this court, sir. Both the parties are advocates from this court, sir. Earlier, a canine proceeding was initiated, and thereafter it was sent for mediation. But mediation report, lordship, it could not be settled. May I pray to take up this matter?
This is against the CRP IU.
In CRP, we have sought for reducing some documents, lordship, and the court
Where?
honorable just
before that court. So we look at here. Why do you need those persons?
Lordship, while after issuing notice, Honorable Justice A.D. Chaudhary has initiated a proceeding of capture.
That concerned learned judge must have thought that this court should try to settle it between them.
Only because
I have no such good intentions. My thing is, the matter before this court is on a 227 application, whether that document is there or not. I'm not concerned with any other.
During pendency, they have filed for IA also, and Court 7 also formulated one question to be argued by the respondent on that interlocutory application also.
We will see when the matter is taken.
Lord,
I'm not going to have it in camera unless.
Lord,
Lordship, I beg to mention item number 35, your lordship.
Wait, let me first close certain matters. I can't take it up. One is item number 33. Not before me. Then item number 29. Not before. Okay. Yes, now then.
Yes, your lordship, I beg to mention item number 35, your lordship. Lordship, with the consent of the other side, your lordship. Matter will be fixed after 2 weeks, your lordship.
At the request of the learned counsel for the
and for the respondent, 1 to 3.
Respondent, the matter stand adjourned to listed after 4 weeks.
Obliged.
Therefore, adjournment, item 45. Lordship, the leading counsel, Mr. S. Samaria is out of station due to some medical issue, lordship.
45.
Letter of absence is only up till today, my lord. So it may be taken day after tomorrow.
Stay matters?
Yes, stay matter.
No adjournment?
Yes.
Lordship, health issue is there. He has already filed a lordship leave application. Lordship, kindly for a
leave application, no leave application, how does it matter?
Lordship, he is meeting down there.
There is Mr. A.N. Sharma. That is Mr. M.M. Jaman. Who are those?
I'm M.M. Jaman.
Oh, fantastic. You are there.
Lordship, kindly.
No adjournment. Stay matters, I vacate the stay and take it over. You want after 6 months, I can give you, but I'll vacate the stay.
Lordship, kindly tomorrow, Lord.
No. Next.
May I please, Lord? I wish to mention item number 72, Lord.
70?
70. 11, Lord.
11.
Matter may be withdraw, Lord.
You want to withdraw?
Yes.
Mr. Name?
P. Kelly.
P. Kelly, the learned counsel appearing on behalf of the appellant, submits that he has instructions to withdraw the instant appeal. Accordingly, the instant appeal stands closed on withdrawal. Interim order, if any, pass stands vacated.
May I please, your lordship? My lordship, I beg to mention for listing a CRP matter.
For
admission, my lordship.
When?
15/3 this Friday.
That's it. We'll have it on 5th. I keep the 5 there and 5th. Friday also. 5th of April.
Highly obliged.
I'm here to mention item number 5 of daily causes. The learned counsel, Mr. A.K. Paiwala, is out of station. So I kindly request to adjourn the matter for today.
Why?
He has gone to his family.
You try your luck. Don't worry. Next. We'll see. I'll help you out. Don't worry. You have a case. If I have to dismiss, then I'll adjourn it. Okay?
Lordship, listing of urgent matter. Urgent matter.
Urgent matter. What is the urgency?
The vacating stay order.
Where? CRPIO?
There's no IA. We have filed IA.
Where?
This school.
Understood. Where? In what application? What matter?
So vacating of stay order. Sir, our order has been passed against us when we are not even the party in this meeting. We are builders, sir. Petitioners.
When do you want?
So 15th Friday.
You'll have it on 18th.
18th.
Yes.
Please, the Lordship, that is CRP.
For motion. When did you file?
File of 7/9/2023.
7/9/2023. It has not been listed for motion even.
Oh, Lordship, has been required, but on that day, it was the difficulty of the part of the conducting that is right.
Okay, 18th.
Lordship, one RFA for this
For
or
order. Why? It has been admitted.
yes, admitted, but
Then obviously it will come up for hearing. Next.
May I please, Your Lordship? Lordship, I beg to mention for Lordship, I beg to mention for listing of CRP matter for
CRPIO,
Lordship.
landlord tenant,
Lordship, for the civil revision petition
for what?
for admission.
Okay. 20.
Lordship,
20.
point. Obliged.
Please file out. I reference on item number 12. Item number 15, sorry.
Item number?
15.
Yes.
Learned senior is unable to appear before the honorable court due to death of his sudden silent friend.
At the request of the learned counsel for the appellant, matter stands adjourned to be listed after 6. Number 1. Yes. What has happened in the meantime?
Well, the pursuant to my lord's order dated 15/2/2024.
Hmm.
Lordship may kindly see order dated 15.
Hmm.
At paragraph number 5.
Hmm.
Respondent
Make
authority.
sure that this correction is duly carried out in the record of rights and the same be placed before this court or next.
No, my lord, pursuant to my lord's directions, an order has been passed, my lord. Yesterday. I have placed the instructions.
Why this online portal has been closed?
Because of my lord upgradation of the software.
Chalo. We'll have it on 21st.
My lord, Lordship may kindly peruse the second page of that instruction. Second page is the order.
So it has been corrected
Yes,
in their name.
yes, everything. Now a new DAG will be created along with a new patta. Because a new patta has to be created. So that will be done. But in the record of right, it could not be, my lord, corrected and
Uploaded.
uploaded, incorporated because
Okay.
of this
We'll
difficulty.
have it on 28/2/8.
2/8, my lord, I have some difficulty. If my lord,
Okay, 2/7.
2/7, yes, 2/7.
List the matter again on pursuant to the order dated 15/2/2024. Passed by this court. Mr. Arbor Pujari, the learned standing counsel of the Revenue and Disaster Management Department had submitted that an order has been passed on 12/2/2024 that has been passed on 12/2/2024, whereby 3 bighas of land that whereby in respect to 3 bighas of land which originally belonged to the plaintiff, the petitioners, was again whereby the correction of the record of rights were done by again showing that the 3 bighas of land in the name of the petitioners. However, in doing so, a separate patta and dag would be created in the name of the petitioners. Further to that, it has also been brought to the notice of this court that on account of the closure of the ILRMS online portal with effect from 5/3/2024 to 23/2024. The said correction of the land, the said record correction of the land in online Jamabandi and Chitta copy could not be done. Mr. Arbor Pujari's, the said instruction is kept on record and marked with the letter A. Mr. Arbor Pujari, the learned counsel appearing on standing counsel, submits that the same would be duly done on or before the next date. Taking into account the above, this court fixes the matter on 2nd of April for an update.
No, yes.
Full stop. It is made clear that on the next day, the Revenue Department of the Government of Assam, along with the district administration, shall do the needful of creation of the patta and the respective dag in respect to the 3 bighas of land, and also prepare the trace map before this court, trace map. The said patta along with the trace map be produced before this court on the next day.
Lordship, may kindly indicate, my lord, I will produce the record of right, because nowadays, my lord, patta, my lord, that is the conventional patta, it is, my lord, perhaps not issued because of, my lord, this online system.
Absolutely it is issued.
And my lord, one another aspect, my lord, I am submitting one another aspect of the matter. That order says, my lord, that it will be corrected in the name of the original pattadar. My lord, what I pray, my lord, let the petitioner, my lord, submit a copy of the NOK, my lord, to the authorities in the meantime, my lord.
Full stop. In the meantime,
So as to
the
facilitate.
petitioner shall also submit a copy of the NOK
Within a time frame.
on or before. You have the NOK?
Because that will be required.
Next of kin of Madhuri is available, but next
You-
of kin.
You have the NOK?
Yes.
Have.
Yes.
Shall furnish a copy of the NOK to Mr. Arbor Pujari by latest by 19th of March 2000.
May I point out one thing, as per Annexure 1/770, that contains 4 bigha 15 acres. Now they are
Yeah.
saying 3 bigha.
Other land is not the problem.
No, 770 dark itself shows 4 bigha 15 acres.
Madam, the other land is not problem. It is already there. Only out of that 3 bighas of land was shown as government. And that is why I have taken the pain out here being a civil court to make all these corrections.
Apply.
Once that is being done, then only you get your right. Then only the acquisition can happen.
Apply.
And so
M. Hussein. Yes, what is this?
Another compensation
Matter
for
related to the
acquisition of
movement.
the Harim
Huh?
outpost, my lord, lordship may remember.
Oh, that outpost.
Yes,
Fine.
my.
Yes, what happened?
My instruction, latest instruction is that, my lord, the amount of rupees 4 lakh and odd, 96,000 and odd, that was paid to the petitioner on 8th of March.
Hmm.
It was sanctioned, released, and she has received it.
Hmm.
That is one part. Secondly,
Shall take immediate steps for payment of the remaining consideration of 4,96,000
that part, that has been complied with.
has been paid.
She has
Okay,
received.
then
Second is, my lord,
further to that, this court directs the respondents to assess what amount
Assess
the
the-
petitioner would be entitled to compensation for the period from so and so on account of
95 to
occupation
20. 90 from 1995
to
to
2020.
2020. That has been, an assessment has been made by the deputy commissioner,
Hmm,
district commissioner, my lord.
yeah,
Uh, including the interest, it will be, my lord, 26,88,934. That has been sent to the home department.
file an affidavit.
Right.
All giving the details.
Right.
You have said that you have paid that amount.
That amount, she has received.
We have not received.
Huh?
I'll show it to you. I'll show it.
Received any information regarding. We have not received any information regarding.
You have not got the money?
Already 5 lakh we have received. No.
No, 4,96,928. 5 lakhs was paid earlier.
Yes, my.
That is not on that.
She has received.
Within these 10 days, have you received this?
Possibly
Last 10 days, have you received any amount? Last 10 or what?
On 8/3.
Almost.
On 8/3.
8-3 you
maybe,
have
my
received.
lord, and the petitioner has not communicated with us.
Petitioner must have got the money and as such not communicated to you. Found it that a lawyer has become useless. Why should I? Isn't it? And if I say that I have got the money, I'll have to pay the fees to the lawyer. Something like that. There is a sign also. Yeah, he's
Maybe,
received.
my lord, wait for it.
Therefore, pursuant to the order dated 15/2/2024, it has been brought to the attention of this court that an amount of rupees 4,96,929 have already been paid to the petitioner on 8/3/2000 or on 12/3/2024. On 8/3/2024. And there is an acknowledgement by the petitioner on 12/3/2024. What is the name of the petitioner?
Lavanya.
Full stop. It has also been mentioned that pursuant to the directions passed by this court,
Assessment, those are here. ma'am.
where? Secondly,
আমি এগুলো বলতে কম।
pursuant to the directions passed by this court, an assessment was carried out as to how much the petitioner would be entitled as compensation for the period from 1995 to 9/11/2020. And also the interest accrued thereupon. Mr. Talukdar,
Ma'am.
this amount of 4,96,929 was a part of the awarded amount.
Awarded.
How are you deducting that out here?
No, there are some miscalculation, my lordship, because the interest was, my lord.
Interest is different. You are to acknowledge that the interest from 1995 till 2010. What is the compensation he will entitled
Right.
to and the interest? How do you deduct to 4,96,000? You cannot do that.
That is part of the awarded amount.
That is a part of the awarded amount. That cannot happen. It has been brought to the attention of this court that the petitioner is entitled to 26,88,934.645 on account of on that said account. However, on the instructions which were placed, it has also been referred that as the amount of rupees 4,96,929 have already been paid, the petitioner would now be entitled to an amount of 21,92,005.65, which shall be considered in the next financial year. Full stop. This court have also taken note of the calculation which will be made on the basis of which the amount of rupees 26,88,934.65 was arrived at. When did you pass the award?
2021.
Then how are you including all these things in this manner? 30% solation? If you have passed the award under that 2021, it has to be as per the new act.
Yes.
That is why I asked.
Right.
What will be the compensation as from 95 you are taking? That will be
95 till
that
date.
is a compensation on account of requisition expenses
Requisition.
on
I'll
rental
have to
value.
explain that. And that part will be requisition.
And then
Then
it has to be
they-
done in this manner. This court, upon perusal of the said calculation so enclosed, and taking into account that the award was passed in the year 2021,
21.
finds that the same is completely contrary to the provisions of section 24(1)(a) of the Right to Fair Compensation Act 2013. Inasmuch as no, ഇതിനല്ലേ.
Post proceeding to 19 notice start course, remand in over to yes.
Now, why have you fixed 70,000 as the value?
That was fixed earlier,
Then how
As
can
a-
that be continuing like this?
my lord.
The value?
Value was probably.
Then if you are saying from there, isn't he entitled to 12% interest on the date from that value? If
On
you are
the-
taking?
On the date from the award,
No.
the interest part will be.
His interest, if we are saying that the value of the land has to be taken as per 1995,
This is may not be 95, possibly I have seen somewhere, it is award, when the award was passed on 16/6/2021.
huh?
16/6/2000.
No. Why this 70,000 was taken? 70,000 was taken, why? It is on the basis of some award statement.
Yeah, I'll go award 32,000. 11 lakh will be still 32,000. 32,000.
Yes. This award statement of 70,000, it was taken.
Yeah, the award, from the award.
Was this the value of the land at that point of time?
Not in 95%.
When? This land is where? Ahim.
High.
Here the bigha is 70,000. Ahim, bigha is 70,000.
More than.
Now it may be more.
No. Then in that case, kindly see the provisions of you, if you have done under the 87 in 1894 Act, the interest at the rate of 12%
After the passing over.
from the date of the award. If you are holding 70,000 as the date, then the 12% will run from then.
From passing of award to.
No, from the date on which the land value was taken.
Yes, ma'am.
So 12% will run from there.
12% will run, my lord, the proceeding started in 2019.
So therefore, the question would be, was the value of the land 70,000 at that point of
Was-
time?
Was fixed at that point, maybe. I'll go to the records, man.
এনেকলে তুমি নালাগে কাটিলি the Mr. B.J. Talukdar, the Learned Standing Counsel, appearing on behalf of the police revenue department, revenue,
Not
no?
revenue, home and police.
Home and political
Lords.
department of the government of Assam had submitted that in pursuant to the order passed by this court on 15/2/2024, the amount of rupees 4,96,928.92 was paid to the petitioner 929 was paid to the petitioner on 8/3/2024. And in that regard, the petitioner had also acknowledged receipt of the same. As regards the compliance to the directions passed in paragraph number 12 and 13, the Learned Council submits that although certain amount have been determined, but the question would arise as to whether the same has been determined in accordance with the applicable provisions of law, for which he would require some more time in that regard. Taking into account the above, this court directs the who is going to do. This
Assessment,
amount has to be paid by the DC.
no, it has to be paid by the requiring department, that is.
Requiring will pay to the DC and DC will pay to you.
Yes.
This court directs the respondents, more particularly the deputy commissioner,
District Commission. No.
district commissioner where? Fahim is where?
And Kamrup, rural.
Kamrup, as well as the Home and Political Department to file affidavits stating as to the entitlement of the petitioner in terms with the directions mentioned in paragraph 12 and 13 of the order dated 15/2/2024. To list the matter again on 2nd of April. In the meantime, the Learned Council appearing on behalf of the petitioner shall also inquire as to whether the petitioner have duly received the said amount. You see the problem which is there, why the 70,000? You have to show it out there in your area that you have taken 70,000. If you have taken 70,000 in 1995, then the interest has to be calculated from then. From 1995 onwards, 70,000, that would be the value of the land.
That was not 70,000 at that point of time.
That has not been done.
So far as I remember.
So and if you have hold it at 70,000 now, and therefore I categorically ask you another aspect of the matter. If you have issued the notice under section, did you issue the notification under section 4? Nothing.
Records are not here.
The Learned Council shall also produce the records of the acquisition proceedings on the next day without fail.
Oh, that will be able,
Yes.
An application on section 24 of the Code of Civil Procedure, Lordship, claim for transfer of TSMAFC case number 430, Lordship, from the Principal Judge, Family Court, Barpeta to District Judge, North Lakhimpur, Lordship. And the hearing, Lordship, the
Now tell me one thing. How long you have been married?
They married, Lordship, 8/12, as per their record, 8/12, Lordship, 8/12/2023, Lordship.
10/12/2023.
Lordship. And there are
And divorce filed.
no, Lordship.
What is this?
Restriction of conjugal right, Lordship.
Restitution of conjugal right.
The husband of the petitioner, Lordship.
And what is your date of birth?
Date of birth, Lordship. I connect, Lordship. Date of birth. The petition is reflected, Lordship, my date of birth, here, page 9, Lordship, 28/5/2005,
28/5/2005.
Lordship. She is a student, of ISS,
Now you don't want to go.
Lordship.
You don't want to go to the husband's place
No,
after getting married. 2 months has only gone.
no, Lordship, only 5 or 6 days, Lordship, because she is a student of SS final examination, Lordship. She is appearing 2024 final examination. She appeared over into 9/3, Lordship.
And then
Thereafter,
thereafter you will go.
no, Lordship, she contests the case.
Why?
because
You got married on 10/12/2023.
because they elope with the both the petitioner the love each other. Thereafter they elope with the respondent lordship,
Then
and thereafter
now you want to study,
lordship.
and he is asking for restitution of conjugal right.
Right. Now they file a petition before at corporate lordship.
And where do you stay?
Not looking to lordship, and he is no sources of independent income lordship. He is the girl, he is a student lordship, and parent of the.
Why did you marry at all?
Because of love affairs lordship, they elope.
When is the next date?
Next date lordship, 6
Huh?
3 lordship, 6/3, which was next date was 6/3. Thereafter, I have checked the e-court, but next date is not updated.
So it must have proceeded ex parte.
Maybe.
Then find out and tell me.
Lordship,
I won't pass such order like. List the matter on, Friday,
okay.
on which state Mr. Telangana counsel for the petitioner shall apprise this court what is the next date in the proceedings before the trial.
Plus.
Yes, what is this?
This is a mathematical issue, my lord. The wife, he filed a divorce petition, my lord. For
Where is the order?
a impugn order is at my lord. 76, my lord, annex of 5.
Huh?
Annex of 5. But the wife, my lord, she filed a divorce petition, and the husband, my lord,
Petitioner, the respondent have prayed for time to file some documents and submitted his draft. Today is not fixed for document and hence the petition is checked. Since the petition is filed by the petitioner, praying for passing a decree for on his consequence has also been. But the parties have not invoked the petition for parties have not submitted down complete.
lordship may come to case.
Your application, your counterclaim has been rejected.
No, my lord. My lordship may come to case 74, my lord, for one. Thing is that, my lord, the wife has paid for a degree of divorce, and the husband appeared. And he filed an WS counterclaim seeking divorce, my lord, but not on the ground. But hereafter, my lord, we filed an application at page 74, my lord. Since both the parties are seeking for divorce, so my lord, the court would have.
Order state the valuable may consider the prayer of both the parties by passing a decree of divorce. Then it is like a mutual consent.
No, my lord, it is no, yes, my lord.
It is like a mutual consent,
But, my lord, the honorable court
but
has
for different grounds.
rejected different ground, my lord.
Then,
Then, my lord, just impugn order was passed, my lord, on,
so this petition was rejected,
yes, my lord.
rightly so. Absolutely. It becomes a case of a mutual divorce. To go and file a mutual divorce and then wait for
He's
6
not coming
months.
forward. The husband is not coming forward, brother. But thing is, since both the parties still for a divorce, ultimately it's for a divorce, my lord. So, my lord, the trial court may go on into that aspect without wasting our prayer was that.
Don't think about the trial court wasting the time. Think about this court wasting the time for this type of matters.
But since there are not allowed, that's all. At least the man it will notice, my lord.
Huh?
Notice it maybe.
Why?
Well, let them come and say, my lord, what they want to say.
Who will say?
My, the husband, my lord.
Okay, if the husband comes out here and says that, okay, I want a divorce, then what am I going to do? Tell me. Can this court pass a order of divorce? Why? Because you have unnecessarily told your client that you are going to file this.
No,
Then
No.
it's an absolutely bogus application. Okay. So, and what has happened in the meantime?
in the meantime, there are cases going on, my lord.
Very well.
Now it's on evidence.
This is an application filed under Article 2 to 7 of the Constitution, challenging the order dated 22/12/2023. Whereby a petition being petition number 853/2023 filed by the petitioner herein was rejected. It appears from the records that you are the wife
And the wife. Yes, madam.
who filed the divorce
I felt that.
initially.
Yes.
It appears from the record that the petitioner herein had instituted a divorce proceeding, being FC Civil case number 1266/2022 before the court of the Principal Judge Family Court Roman 2 Kamrup Metro Guwahati on the ground
On the ground of cruelty, madam.
cruelty. The respondent, who is the husband, duly appeared in the said proceeding and filed a written statement along with a counterclaim. In the said counterclaim, the respondent also sought for a decree for divorce. Pursuant thereto, the petitioner herein filed an application which was registered as petition number 853/2023, stating inter alia that as the petitioner as well as the respondent have both sought for divorce, the court should, in order to save the valuable time, should grant the divorce. The learned court below, the learned trial court, by the order dated 22/12/2023, had rejected the said application on the ground that where's the Hindu Marriage Act?
And last page, madam, 76.
Hindu Marriage
Last.
on the ground that as both the petitioner and the respondent have not invoked the provisions of section 13 capital B of the Hindu Marriage Act 1955, the said application was not maintainable. The said order has been put to challenge before this court under Article 227 of the Constitution. This court, upon perusal of the said application, the said order, the impugned order dated 22/12/2023, as well as the provisions of section 13B of the Hindu Marriage Act 1955, finds no infirmity in the said order, for which the question of interfering with the said order, impugned order dated 22/12/2023, does not arise. Accordingly, the instant petition, therefore, being without any merit, stands dismissed. Before parting with the record, this court would like to observe that the learned court of the Principal Judge Family Court number 2 Kamrup Metro, taking into account that both the parties have sought for a decree for divorce, may counsel both the parties to before party. Yes. What is this?
I am not on record, my lord.
I just wanted to sign tomorrow, Lord, but the timeline is not there.
No case.
But
Your-
this is pending.
The earlier person who mentioned the matter, if she was available, I would have adjourned the matter till when right. But as you are an experienced lawyer, so very well. Now I'll dismiss it on your face. Okay.
But I have not read through the file, Lordship. I just read it here only, Lordship. I have just read the file here only, Lordship.
Where is Mr. A.K. Sahewala?
He's out of station.
Where?
So that
Tell that. We'll have it at 2. Ask him to be there in video conference.
Hello. Let me.
Hmm.
The violation of the order dated 10/3/23 was by this judgment order dated 10/3/23.
What violation?
Violation, Lordship, page 23 and 24 operative portion, Lordship will find it paragraph 25 and 26.
In the result, appeal is disposed of with the aforesaid modification awarding the so along with so. The Oriental is directed to discharge the liability of the award within 30 days from date of receipt. Insurance company is directed to make the payment of the amount of the saving bank account and she is directed to furnish her bank details of. Yes,
Thereafter, Lordship, we have submitted that judgment order on 18 March 23, followed by again reminder on 22nd August 2023, but no action has been taken.
Huh?
No action has been taken. Within 30 days, it was directed to release.
so
But now it is almost 1 month, 1 year.
you know how to, these are a decree. Go and execute it. You want this court to be the executing court?
No.
Oh,
Pass a direction to the,
why should that? This court has already passed that yes, you are entitled to this 14 lakh.
Yes.
If it is not given, go before the MSCT court and tell them that look here, this is it, execute the decree. This is not the case. You can't file a contempt for that. Tomorrow, everywhere the contempt will be filed. Second appeal, a judgment has been passed, a decree has been passed, it has not been complied with, so unless such a file a contempt. Go and execute. The learned counsel appearing on behalf of the petitioner submits that he would like to withdraw the instant proceeding and shall proceed for execution of the award before the learned court of the which one?
Code of the Motor Accident Claim Tribunal number 3, Kamrup Metro.
Huh?
Kamrup Metro.
Learned
Motor Accident Claim Tribunal
Motor
number
Accidents Claims Tribunal number
3.
Three.
Roman 3.
at Kamrup Metro at Guwahati seeking enforcement of the award passed by this court.
Obliged.
The instant proceeding stands closed on withdrawal. Full stop. The The withdrawal of the instant proceedings shall not prejudice the petitioner to approach the state court for enforcement of their work. Astinate MAT appeal on that. Yes, what is this? Oh. Hmm.
This petition is against the order for rejection of the implement petition and amendment petition.
Hmm?
This CFT is against the order for it has passed against a implement petition and amendment petition. There was a
What orders you have challenged?
order is at page 33.
So was why the impugn order dated 28/11/2016. 28/11/2016 is where?
Page
Yeah.
33.
This suit is at the stage of trial. In fact, the cross-examination of PW1 was going on when the plaintiff came up with a impede a person as a party to the proceeding. The defendant have objected to the same by drawing any attention to the written statement. In addition, I find the defendant had taken the specific plea that so and so is a necessary party to the proceeding. But the plaintiff ignored such pleadings and did not take any test or implement of preventive then what therefore comes up that there is a deliberate attempt on the part of the to impede one of the only when the plaintiff is point out that also 20 lays out that non-impedient What is your application, Tommy? You wanted to withdraw the suit.
No.
Then why is order 23 being referred to? Where's your application seeking impediment? Okay. Well,
Page 28.
filing the input in the You want to make Snehalata Sarkar as a performer defendant?
Yes, Lord.
If it is a performer defendant, then how he is a necessary party?
Lordship, he is a daughter of
The council, I don't understand a basic necessary party would be whom?
again,
Whom you have to seek a relief. How can you make him a performer?
Lordship, this is a partition suit, Lordship. And she is also a person who have interest in the property, Lordship. But she have relinquished her rights. As she was given 1 acre of land by her father, she have relinquished her right. But Lordship, she have also interest in this property, Lordship.
He has interest in the property.
Yes, Lord.
And you have not made a party.
Yes, Lordship.
Yeah, rightly.
Because it was not
What
pointed.
is the property?
Property is that, Lordship.
What is suit for declare? Yeah.
Suit is for declaration, partition, and confirmation of possession.
Where is the property?
Property is at Bongaigaon Road.
How much is the property?
1 acre, 7 lakhs.
Bongaigaon town. Well, 1 lakh cost.
Lordship, 1 lakh.
1 lakh is the cost. Highly see.
Lordship,
In the no, Mr. Kang.
Okay.
Written statement they have duly mentioned. You did not amend your pleadings then. You went ahead. It went to framing of issues. Evidence given by the plaintiff. When you are being questioned out there during the evidence that you have not made, you have made a big mistake, then you must have told your client that what have you done? The lawyer said that now we will file this application. So, all these dates, the defendant have appeared, the defendant have paid fees to the council. Who is going to bear the cost? You have to bring that suit to that portion. Na? You have to compensate. So 1 lakh, I think, is the minimum. If it is the going rate. Isn't it, Mr. Bhuya? What do you say? Wouldn't this suit go back to that stage?
Lordship.
The moment it will go to the filing of the written statement, meaning thereby the entire exercise of payment of the lawyer's fee. You don't practice in the trial court? Have you? Have you ever appeared for the defendant or plaintiff? Have you faced the agony out there when an amendment is allowed? And again going back, and then you are answerable to your client that this has happened, and now the client is very sad because of the fact that all this while, whatever has happened has become a not. No cost.
1 lakh.
Okay, make it less. 99,000.
Okay.
In your face, 1 lakh. Where's the other side?
None has appeared, Lordship. They have refused to accept. They have
Okay.
refused to accept.
We allow it subject to a cost of 75,000. This has to be, it has to be a precedent because not, if it is not being done, it will show a very poor people. I don't know whether you have practiced, but I have seen it when I was practicing in the trial court. This is the usual phenomena. Now, what are you have filed this application out here. What is the amendment you are asking again? Nothing.
Amendment, Lordship, at page 29, para 11, Lordship.
So, you are now asking for amendment of your plain, which means they have to again file an additional written statement. Then, and that too in one petition. You have saved that money also of filing one petition of under order 1 rule 10, order 6 rule 17, which are completely separate proceeding. I would have understood order 1 rule 10 only for the purpose of bringing somebody for which you make an application out there. It will come under order 1 rule 10.4. That is another aspect. 85. Reasonable. Chalo.
50,000. 50,000.
9. This is an application under Article 2 to 7 of the Constitution challenging the order dated 28/11/2018 passed in title suit number 6/2016. From the materials on record, it reveals that the petitioners herein, as plaintiff had instituted a suit being title suit number 6/2016. The said suit was filed seeking declaration, partition, confirmation of possession, as well as for injunction. Pursuant to the filing of the said written statement, the suit, a written statement was filed by the defendants. In the said written statement, Where's the plea of Snehalata?
Lordship, in our treatment petition.
Huh? No. You want to make Snehalata Das. Where is the mention in the written statement? Ah. No. Ah. In the same written statement at paragraph number 10, it was categorically mentioned that on the death of late Ghanshyam Das, there were 7 legal representatives, which included one Srimati Seno Das, Senno. The said statement has relevance taking into account that in paragraph number 2 of the plaint, the plaintiff had only stated that late Ghanshyam Das left behind 6 legal heirs. Thereupon, issues were framed. Thereupon, issues were framed and evidence adduced by the plaintiffs. At that point of time, at the time of process, in the midst of the cross-examination of the plaintiff, witness number 1. An application was filed under Order 1, Rule 10(2), read with Order 6, Rule 17, seeking amendment of the plaint as well as also the implement of one Seno Das.
In our impeachment petition, we have mentioned the Snehalata.
To implead one Srimati Snehalata Das alias Sarkar as one of the defendants to the suit, and also for amendment to be carried out as stipulated in paragraph number 11 of the said application. The said application, upon being filed, was rejected by the order dated 28/11/2018, for which the petitioner has approached this court, petitioners have approached this court by filing the instant proceedings. This court had heard the learned counsel appearing on behalf of the petitioner. and who submitted that the entire suit of the plaintiff would be dismissed on a technical ground if the said Snehalata Das alias Sarkar is not impleaded as a defendant. He further submitted that the amendments which have been sought for, as stated in paragraph number 11 of the said petition, would not change the nature and character of the suit, but the same are essential for the purpose of proper adjudication of the suit. He further submitted that no prejudice should be caused to the defendants if those amendment is being inserted. Further to that, it was also submitted that prior to the trial, the suit could not be, the amendment was not filed on account of the advice not being received, for which the petitioners should not be allowed to pay such a heavy price. Did I say more than that? What you thought? I've heard the learned counsel appearing on behalf of the party. Upon hearing the learned counsel for the party of the petition, and also perusing the copy of the plaint and the written statement, it is the opinion of this court that without making Snehalata Sarkar, Das allied Sarkar, as a party to the suit, the relief, more particularly for partition, would be the relief of partition which have been sought for would not be complete. This court have also taken note of the amendments which have been sought for, which in the opinion of this court would not change the nature and character of the suit. Although there has been a delay in filing the said application seeking impleadment, and the amendments which have been sought for. But in the opinion of this court, for the ends of justice, the said amendment is required to be, said impleadment as well as the amendment is required to be permitted. Accordingly, this court impledes Srimati Snehalata Das alias Sarkar, daughter of late Gyanchand Das and wife of late Shivendra Narayan Sarkar, resident of village Khanabari, Ponai Noyoni, Bogribari, P.O. Bogribari, P.S. Goripur, in the district of Dhubri, Assam, 783331, as the defendant number 6 to title suit number 6/2016. This court also permits the amendments which have been sought for in paragraph number 11 of the petition bearing number where's the petition number?
Petition number is not.
Huh?
not-
No petition number. Of the application filed under order 6 rule 17 read with order 1 rule 10-2 before the learned trial court. The petitioner, petitioner who is the petitioners who are the plaintiff are directed to file the amended plaint before the trial court on 13, 14 days on 27/3/2024. Interim order was there. The interim order dated this court, however, also finds it relevant to take note of that it was on account of the latches, on account of a delay, that on account of the plaintiffs latches, the suit which has now proceeded to the stage of evidence would stand relegated to the stage of pleadings. Which would occasion, therefore, the delay in disposal of a suit, which is almost 8 years old. Under such circumstances, this court, therefore, is of the opinion that some certain cost has to be imposed upon the petitioners while allowing the said applications. Else, prejudice would be caused to the defendants who had all along participated in the suit. Accordingly, this court imposes a cost of 85,000. So this court is of the opinion that an amount of 85,000 shall be the reasonable cost which can be imposed in the instant case. This court directs the plaintiff to deposit the cost of the 85,000 before the learned trial court along with the amended plaint on 27/3/2024, and the deposit of the said cost of rupees 85,000 shall be a condition precedent for acceptance of the amended plaint. The defendant would be at liberty to file appropriate application before the learned trial court for release of the said amount, and the learned trial court on such application being filed shall permit the release of the said amount. The interim order passed on
25/2/19.
25/2/2019 stands vacated in view of what has been directed above. Let's make it 75.
Plaintiff right title interest over schedule A to the plaint are decreased. The plaintiff is given confirmation of possession over stood land in the Schedule B to the plaintiff. Plaintiff is given as possession of the land mentioned in Schedule C. Now, Schedule kindly. Schedule A. Plot of land measuring 4 katha 7.5 lesa out of 1 bigha 12.5 lesa covered by tag number 133. Dispute is with respect to this 133 because I am also claiming that I have also purchased 2 katha 10 lesa from this 133. Now, when this schedule has been given, the entire land schedule has been given. Schedule means boundary. And from my prayer is that from 133, this 4 katha, 7.5 lesa be
Mr. Ghosh,
partition.
Mr. Ghosh, the decree says that right title and interest is given in respect of Schedule A.
Okay.
Right title and interest, let us see in respect to what land it is. A plot of land measuring 4 katha 7.5 letters out of 1 bigha 12.5 letters covered by tag number 133 and 2 katha 10 letters covered by tag number 134. In total 1 bigha 1 katha 17.5 letters have been given.
Yes.
Of PP Patta number so and so have been given. So these are 2 plots of land have been given.
Yeah.
Now, as regards Schedule B land, it is a confirmation of possession.
Yes.
Now, Schedule C land, a plot of land measuring 2 katha 12 letters of tag number 133
130.
out of the suit land of Imad with 1 pakka house with CIC's house having bamboo fencing with CIC which is bound by so and so.
Yeah.
Then what is wrong?
Wrong. I'm not saying wrong. It is in the Schedule A land in 133 tag number. There are more than the decreted land.
Huh?
More than the decreted land. A plot of land measuring 4 katha 7.5 lesa out of 1 bigha 12.5 lesa.
Hmm.
So he is claiming 4 katha 7.5 lesa from 1 bigha 12.5 lesa. Our case is that from this 133, I have also purchased in the year 1974. I am purchased less 2 katha 10 lesa. So let the partition be affected with respect to 133 tag number because in the boundary which has been given, he has
Mr.
given
Ghosh,
entire
it is a
boundary.
case of appeal. It will be at best a case of appeal. How can you raise all these issues in the
My
executive
lord,
court?
I am not against the decree. I am only that decree which has been passed. Let the correction, not correction, let the demarcation be made with respect to 133 tag number because there are more, not the decreted land, there are other land also there. So other land will be segregated from 133. That is my simple prayer.
Here he says that out of tag number 133 contains 1 bigha 12, 1 bigha 12.5,
Half lesa.
of which 4 bigha, 4 katha,
4 katha.
7.5 letters,
Sir,
which means
this land.
remaining land is almost 1 bigha 5 letters. 1 katha 5.
Yes.
1 katha 5
5
letters
letters.
remain. So out of 1 katha 5 letters, you say that you have 2 kathas of land or whatever.
Whatever it is,
I'm not concerned.
I'm not concerned.
Of this will be done.
This should be done, my lord.
Yes,
This,
why you?
it's already there. But when they are executing, the boundary which has been given, the schedule of the boundary, that is entire 133, entire land has been given. That is my dispute. With
No. The possession can only be in respect of 2 katha 12 letters.
Yes.
So
Without mentioning the boundary, because in some part of the land,
no,
I am in
it has the decree has to be executed in terms of this. That's all. And in view of that judgment of Susila Devi or whatever 2003 2 SCC,
Yes.
the executing court can very well do that.
Yes, that is the executing court.
What is
can-
wrong? You want to withdraw?
No, I have
No,
filed
what
that
else?
application that was rejected.
Very well, rightly rejected. What is your application?
Application, kindly see, my lord, at page 30,
Para 4.
para 4. both the judgment debtor and decree holder co-sharer and co-partaker of PP number so-and-so of DAG number 133 of so-and-so. The judgment debtor predecessor, one Harichandra Vishwas has purchased 2 kata 10 lesas of land of DAG number 133 in the year 1974. In a part of that particular land, the present judgment debtor are residing, and major part of the plot land has been enjoyed by one Dinesh Vishwas, and the same has been enjoyed by their legal representative so and so, and not the parties in the suit. The said, and up till now, there is no line of demarcation in between the land of the judgment debtor and decree holder.
So you want to delay the execution?
No.
It is already
I'm
stayed, man.
only praying that
That judgment which imposes cost, what is that? Ravinder Singh, what is that? 2003 8 SCC. What is that judgment? On the judgment on that aspect, wait, let me find out. 2003 8 SCC, there is a judgment. No? All you had all that thing as regards 2 kathas land you had in DAG number 133. You must have stated in your plain written statement also.
Yes.
Then that has not been considered.
Correct.
If not considered, how can you raise all these issues here? Now, where is the
I am not
judgment for
raising- I am-
imposition
I
of
am
cost?
only with
Wait,
respect to that
I am only
their
saying,
land may be demarcated with the land of 133. This is my only prayer, man.
where is the judgment on that? Imposition of cost. That is the only thing I. Well, yes. Did you get anything, Mr. Counsel?
My lord.
The 2003 ATCC, what is that judgment? I forgot that.
More than.
Yes. 2003 ATCC 289. My internet good.
Assembly for 20 seconds. Delayed, I think.
No. This is an application under section 115. 115 or 227, which one do you want?
227.
227.
Your application, if allowed, would have disposed of that proceeding. 115. This is an application under 115 of the Code of Civil Procedure 1908, challenging the order dated 11/7/2022, passed by the learned Munshi Poliabot in title execution case number 9(K)/17, whereby the application filed by the petitioners who were the judgment debtors was rejected. From the materials on record, it transpires that the plaintiff, that the decree holders, who are the respondents herein, respondents, na?
Yes,
You
ma'am.
file
Yes.
all the respondents.
Yes.
Biswajit, it is Vinodha. The respondents herein, as plaintiff had instituted a suit being title suit number 8(K)/2013, seeking declaration of right, title, and interest and recovery of khas possession and comma, right, title, and interest, comma, recovery of khas possession and permanent injunction. In the said suit, it was the specific claim of the plaintiff
Issue number 3, my lord, page 16. Everything is there.
that they were the owners of a plot of land measuring 1 bigha, 1 katha, 17.5 lechas, which comprised of 4 katha, 7 lechas, 7.5 lechas, out of 1 bigha, 12 lechas covered by dag number 133, 12.5 lechas, out of dag number covered by dag number 133, and 2 katha, 10 lechas out of 1 bigha, 1 katha, 17.5 lechas in dag number 134 of PP patta number, of PP number 25 of Kisam Des Pulidunga under Moza Borbogia in the district of Nagaon, Assam. It was also the specific case of the plaintiff that the defendant, without having right, title, and interest in possession, encroached upon a portion of the said suit land as described, which was specifically described in Schedule C to the plaintiff on 10/7/2012. It is under such circumstances the plaintiff sought for confirmation of possession and sought for recovery of possession of the Schedule C land, which, as per the plaintiffs, were encroached by the defendants, and for confirmation of possession of the remaining land, which was specifically described in Schedule B.
Not remaining, my lord. There are short of land.
Huh?
Short.
How much is the total land? Two kathas and 1 katha 15 lechas, 3 katha 15 lechas plus 2 kathas, 3 kathas 15 lechas plus 2 area 17 lechas is 1 bigha, 1 katha.
134, 1 bigha, 1 katha, 17.5 lesa. They sought for confirmation 134, only 2 katha. And no recovery with respect to, and 10 lesa recovery from 134. And 10 lesa.
One katha 15 lechas. 2 kathas. And sought for confirmation of possession in respect to the remaining land. This court at this stage finds it relevant to take note of that the Schedule C land, which have been claimed to be encroached by the defendants, had measured 2 katha 12 lechas covered by dag number 133 and 10 lechas covered by dag number 134. The defendants, pursuant to the filing of the suit, filed a written statement raising various preliminary issues. On merits, it was stated that as per the Jamabandi / the patta of the suit land pertaining to Moza Borbogia, Kisam Pulidunga under PP number 25 covered by dag number 133 and 134, the total land under dag number 133 has been shown as 1 bigha 4 katha 3 lechas, and under dag number 134 have been shown as 2 bighas 1 katha 10 lechas, and the total land of both the dags was 4 bigha 13 lechas. It was further mentioned that the father of the defendant number 1 had purchased a plot of land by the deed of sale dated 5/3/1974. Of an area measuring 2 katha 10 lechas under dag number 133 of the 133 of periodic patta number 25. And another plot of land of similar quantity in dag number 77 of PP number 24. Therefore, the defendant had title over 1 bigha of land. On the basis of it also appears from a perusal of the judgment that the defendants took the plea of adverse possession, inasmuch as amongst the various issues framed, one of such issues pertained to Article 64/65 of the Limitation Act 1963. The learned trial court, after perusal of the evidence on record, while deciding the issue number 3, categorically had come to an opinion
Page 19,
That-
Malud, second para,
the plaintiff
different letter.
had purchased the suit schedule land from Devendra Biswas through the sale deed and later on mutated their name. While deciding the issue number 4 as to whether the plaintiff had possession over the Schedule B land, wherein the plaintiff sought for confirmation of possession, the learned trial court, on evidence on record, came to an opinion that the plaintiff had possession over the Schedule B land. While deciding then the issue number 5 as to whether the plaintiff is entitled to cast possession of the Schedule C land, the learned trial court, even after taking the fact that the defendants have duly claimed 2 katha 10 lechas covered by dag number 133 or PP number 25, came to an opinion that the plaintiff was the absolute owner of the said land and as such entitled to recovery of the Schedule C land. Full stop. On the basis thereof, the learned trial court decreed the suit, thereby declaring that the plaintiff had right title and interest over the suit land described in Schedule A to the plaintiff, semicolon. The plaintiff it was declared that the plaintiff would be entitled to confirmation of possession over the suit land described in Schedule B to the plaintiff, and the plaintiff would be also entitled to recovery of cast possession of the land mentioned in Schedule C to the plaintiff by removing therefrom the defendants and their men, agents, etc., after demolishing of the illegal structures, construction of the 4 houses standing thereon. On the basis thereof, the said decree was prepared. It is also seen on record that as the plaintiff was not able to get the delivery of possession on the basis of the decree, an execution proceedings was filed, being title execution case number 9 K 2017. In the said application, the defendant again raised the issue as regards the purchase of 2 katha 10 lechas of land by Dag number 133 of PP number 25, which was duly taken note, as already stated herein above, by the learned trial court in passing the judgment and decree on
20 July 2015.
Thirteen 7/2015. Pusto. That the defendant had filed. The defendants, who were the judgment debtors, filed an application again raising the issue of 2 katha 10 lechas purchased by their predecessor in interest in Dag number 133 of PP number 25, which was duly taken note of by the learned trial court in its judgment and decree dated 13/7/2015. The said issue, the said application, or the said issue which was raised by an application under section 47 of the Code of Civil Procedure. This court, on the basis of the said application which was filed, the learned trial court, the learned executing court, by an order dated 11/7/2022, rejected the said application, and it is against that the instant application has been filed under Article 2 to 7 of 115 of the Code of Civil Procedure. This court have duly taken note of the facts and also heard the learned counsels appearing on behalf of both the parties. A perusal of the application under section 47 filed by the judgment debtor, that is the petitioner's hearing, categorically show that the same issue which have already been decided in by the learned trial court have been again raised by the learned trial court in the suit, is again being raised in the execution proceedings. The same, in the opinion of this court, cannot be done, since a challenge being made to the judgment and decree, which admittedly the judgment debtors have not done. This court finds it profitable at this stage to refer to the judgment of the Supreme Court in the case of Ravinder Kaur versus Ashok Kumar and another, reported in 2003, 8 SCC 289, wherein the Supreme Court had dealt with raising similar issues which have already been adjudicated, raising issues pertaining to description of the land which have already been decided by in the trial proceedings. The Supreme Court observed in paragraph number 22 that raising a dispute in regard to the description or identity of the suit scheduled property, or a dispute in regard to the boundary of the suit scheduled property, is only a bogey to delay the eviction by the abuse of the process of the court. It was observed that a court of law should be careful enough to see that such diabolical plans of the judgment debtors to deny the decree holders the fruits of the decree obtained by them. These types of errors on the part of the judicial forums only encourage frivolous and cantankerous litigations causing laws delay and bringing bad name to the judicial system. Paragraph number 22 of the said judgment is reproduced hereunder. In the instant case, the facts are similar, wherein the petitioners who are the judgment debtors, after having suffered the decree, have now again sought to raise the issue as regards the description of the property which have been duly adjudicated. This court have also seen that the decree which have been passed by the learned trial court and the schedules mentioned therein are clearly identifiable. Under such circumstances, the application which was filed by the judgment debtor is on the face of it misconceived. Considering the above, it is also seen that on account of the said delay, said application being filed, a delay has been caused to the execution proceedings and thereby depriving the judgment debtor of the fruits of the decree. So considering the above and taking into account the conduct of the petitioners who are the judgment debtor, this court dismisses the instant petition with a cost of 75, 50,000.
Poor litigant. Poor litigant. It is
Very
up
well.
to your lord.
50,000. Poor lady,
Poor litigant.
poor lady. You have a lawn. Old lady, filed by Manik Biswas.
No, poor litigant.
There's no poor litigant out there. By anybody who has the, yeah, okay, 25,000. Earlier, Supreme Court in
Yes, sir.
2003 gave
Yes,
25,000. So I thought that in 20 years' time, it should be increased
Double.
by another zero.
Double as much.
Interim order so far stands vacated, taking into account that the parties are duly represented. This court directs both the parties to appear before the learned trial court again on 3rd of April 2024, so that the execution proceedings are taken up for further disposal.
Aye.
Yes, what is this?
Lordship, decision as per your lordship against the order, refusal of injunction order passed by the learned trial court.
Yes, I will give IA anyway.
Lordship, there is I also.
I know IA has to be there.
Lordship, the matter is very simple.
Matter is simple, but why the appeal has not yet been admitted from 2000, such a long time? No order has been passed.
Lord.
Was there any delay?
No,
No.
no, Lord. There is no
What is the injunction order?
Lordship.
Refusal?
Refusal.
Where?
That is an order, Lordship, that is an annexer 6, your Lordship, at page 70. Order dated 17/6/2023.
17. Page?
Page 70,
This is finally done.
Lordship. Because this order has been, the miscases were disposed of by the learned trial court. Injunction has been rejected.
And what is the stage of the suit?
Now the evidence is going on.
So let it remain. Why do you need the injunction now?
No,
Nothing
Lordship,
is-
one thing.
What is the injunction you ask?
Lordship, what happened?
Selling or
Secretly-
letting out,
Lordship.
alienating, selling, letting out, or otherwise dealing with Schedule X properties or
Lordship.
any part thereof.
Lordship.
Let us see your injunction application.
Injunction application, your Lordship, at page,
Who is trying to sell?
the builder, Lordship, respondent,
So did you give an agreement?
Lordship. there's an
You have
agreement.
entered into an agreement.
Lordship.
So what is your right?
Development agreement of the 2005.
Huh?
Initially, there was a development agreement of the 2005.
Ah.
It was executed by our predecessor.
Hmm.
Thereafter, what happened, Lordship, when the respondent did not comply with terms and conditions
Hmm.
of the earlier development agreement, so there was a suit
Hmm.
in the year 2009.
Hmm.
Ultimately, the matter was settled. In the year 2010, we have another deed of memorandum understanding between the parties. So as per that memorandum understanding, that the predecessor were entitled to get 50% of the built up area in each floor. So when that
This
also
is
not
in respect to which suit? What is the number of the suit?
title suit number 125 of 2011, that is a subsequent suit.
No, we are concerned with which suit?
125 of 2011.
We are in 2024, suit has not been disposed of.
No.
Why?
So I am to cross-examine his witness. So the witness of the so far the plaintiff side is concerned is completed. So already the earlier
You are the plaintiff.
I am the plaintiff.
And
So
then-
plaintiff, we have been substituted on the death of our predecessor.
Understood. Now, what is the stage of the suit?
Suit now I am going to that the appellant side is going, sorry, appellant plaintiff side is going to cross-examine the defense witness. DW.
Proceed. Finish it.
Definitely will go to cross-examine.
No.
Lordship, at least, Lordship, one thing that I am not admitting from the evidence is clear that
I will only say one thing. That
Lordship.
I'll close it.
Lordship,
However, any alienation so made shall be subject to section 50.
Lordship.
That's all. Nothing you mean. No.
Subject to final outcome. Subject to final outcome.
52.
Lordship.
52 of the transfer of property.
Lordship.
That's all. Nothing. Okay. The instant appeal has been filed under the instant appeal has been filed under Order 43, Rule 1R of the Code of Civil Procedure 1908, for short the code, challenging the order dated 17/6/2023, passed in Ms. Case number 323/2020, arising out of title suit number 11125/2011. By the impugn order dated 17/6/2023, the application seeking injunction was rejected. The application seeking injunction restraining the opposite parties, their men agents from alienating, selling, letting out on or otherwise dealing with the Schedule X properties or any part thereof was rejected. This court, having taken into account, this court have, during the course of the hearing, have asked the learned counsels appearing on behalf of both the parties as to what is the stage of the suit, taking into account that the said suit pertains to the year 2011. It has been submitted at the bar that the said suit is at the stage of cross-examination of the defendant's witness. Therefore, it is seen that the suit is at the stage of culmination. Under such circumstances, this court is not inclined to interfere with the order dated 17/6/2023, passed in Ms. Case number 323/2020. More so, when such an order has been passed in exercise of the discretionary jurisdiction by the learned trial court, for which, accordingly, the instant appeal stands dismissed. This court, however, before parting with the record, finds it relevant to observe that the principles of, what is the principle? Lispendence as conceptualized in section 52 of the Transfer of Property Act 1882 shall duly apply in respect to any alienation, selling, letting out, or otherwise dealing with the Schedule X properties or any part thereof. The same shall be duly taken note of by the learned trial court while deciding the suit. With the above, the highest sense stands closed, evades the charge.
Right.
নহয় এইটো এপিলত এপিলত হ'ব I to close the in view of the dismissal of the appeal. Yes.
But here, I have filed the I. I could file the I here. I have given copy and I have an extra copy. I have filed the I under order 41 room 5. We have filed it today. I could file. I have given copy to myself.
I has come. No, without the I have to pass the order in the I.
Correct.
Mr. Deenath, the learned counsel appearing on behalf of the appellant, submits that the interlocutory application under order 41 rule 5 of the code have been duly filed. However, the same is not on record. List the matter on 23/2024. The registry shall bring on record the said interlocutory application. Yeah. What is this?
This is arbitration exit under section 37.
Under section?
37.
Yes.
Exactly.
What is it? Section 37 appeals are very difficult. Yes, tell me. You don't think that this is a regular first appeal. Yeah.
Such a matter may be taken after some time.
First, let me be satisfied with Mr. Mohanto as to whether this appeal needs to be admitted, because we are to look into as to whether it comes within the ambit of the principles of 34.
Your lordship kindly see my lord page 22, my lord. This
34 application was rejected or allowed?
my lord, rejected.
Rejected. Tell me what. Tell me then what is the perversity?
Perversity is that my lord, the main question your lordship kindly see that
When was the application filed? 23.
page 20, my lord, annexure 1,
No, the application was filed in 2023.
my lord,
So therefore, the 2019 amendment comes into play.
my lord.
So the scope becomes more or less. Arbitration account. Just tell me what is wrong.
What is wrong, my lord? Your lordship kindly say there are 3 circles in Jorhat district, Jorhat East Revenue Circle, Jorhat West Revenue Circle, and Jorhat York Revenue Circle. The York Revenue Circle, my lord, we are under the York Revenue Circle, my lord. There are 8 villages, my lord, they are York Revenue Circle. And this, my lord, they are other revenue circle village where, my lord, is a rural area. But York Revenue Circle, my lord, this 8 village was, my lord, treated as a, my lord, urban area ratio, because if it is within the rural area, then my lord, ratio will be multiplied, ratio is 1.5 to 2, my lord. So, my lord, in arbitration proceeding, my lord, there one circular, one letter was produced by the government, my lord. That, my lord, York Revenue Circle was, my lord, by way of a letter in 2016, because this land was actually notified in the 2009. So notice was issued in 2009. So, my lord, in 2000, when, my lord, arbitration proceeding was, my lord, going on, then one letter was produced, my lord, that letter was, my lord, said that York Revenue Circle, it is a town committee now. So that's why, my lord, they are treated as a town committee. So we are not getting the benefit of the, my lord, that urban area, rural area. So your lordship will be clear, my lord, if your lordship go to the, my lord, stateway, my lord, page 22. Page 22, my lord.
When was the land acquired?
Initial notification, yes, 2009,
No. Initial compensation was paid when?
paid 2014.
14.
There are 16 of the my lord impugned judgment, your lordship will find out.
Yes.
My lord, there are 16 of judgment, your lordship.
Hmm.
There are 16 of the,
I've read it. Tell me. Which one?
there are, page 56, my lord.
Yes, I've read it.
So, my lord, that your lordship kindly see that is not applicable because we are not treated as, my lord, we are treated as, my lord, York Town Committee under that York, and we are, this their villages under, my lord, treated as under York Town Committee. But at the time of when initial, my lord, notice was issued, it was not under the York Town.
Let us see your statement of claim.
My lord.
Where? Not
Page
there.
22, page 20, my lord.
Huh?
Page 20, annex 1.
No, this is 34.
Yes.
Where is your statement of claim?
Statement of claim.
Where is your land? Tell me.
Para 6 of the my appeal petition. Para 6 of the my lord 34 petition.
Page 31, para 6.
Para 6.
All landowners thereafter approach the respondent authorities, including respondent being the competent authority for redressal of the grievances and enhancement of the court. The appellant states that such attempts on the part of the landowners failed to be owing to the same various landowners across Jorhat, specifically Suenso, including appellant herein formed 4-lane committee for the creating of a unified Suenso. Where is your statement that your land is in those villages? In your application? No. No,
No, my lord,
no, not a single line.
no, yeah, our initial claim is also that, my lord, if your lord.
The initial claim is not before it.
Then, my lord, I'll hand it on all that even, my lord, here, what happened in this case, my lord, even the certified copy of the award was not been given to me, my lord. I was filing a writ petition, and after filing a writ petition, it was served on me, my lord. All the document is very difficult to get, my lord. Very, they keep it very secret, I do not know.
First, you have to say where your land is.
So my land is, my lord, in another Tioga revenue circle, my lord.
Let us see the award.
Page 22, my lord.
Who has filed this? You were you a party out there?
My lord.
How?
No, my lord, the representative capacity, he has filed this, my lord.
Huh?
Representative capacity,
This one?
my lord.
This is under what provision? You are filing for whom? My goodness.
Your lordship kindly.
First of all, how did this arbitration is going on in this manner? Each person has an individual right.
By committee, my lord, your lordship kindly speak. I'll satisfy your lordship, my lord, in that point, my lord. She came some other date, my lord. I'll prepare and I'll. Because he is a representative capacity, he is filed this, my lord, and
From April, I may not be sitting in this bench. You may try your luck then.
my lord, this is my first arbitration appeal, my lord. I have to took because I have not even said, even done for the entire record, my lord. Entire record is, my lord, not available to us, my because of this certain.
First of all, how are you filing this type of arbitration? 34, every person has to go. I don't understand how this is being happening. Maybe most probably these people may have joined all together. Everybody's cause of action will be different.
No, that I have,
Your land, a person A's land will be different from B.
my lord. No, he is also one of the, my lord. That the
He's, how do you know that he is one of it? It is not mentioned anywhere.
I'll find it down and they are usually.
The entire proceedings, in fact, the arbitration appeal, whatever may be, is wrong.
No, individual notice was issued, my lord. I have done for the, my lord, done for the award, my lord, that individual notice was, my lord. They said that we send the individual notice.
Because your only issue is as regards the multiplication factor. But the question is where your land is. How can that be said that for each person it will be different?
No, they are that entire revenue circle, my lord. Entire, my lord, Tioga revenue circle, my lord. The land which was under the revenue, that revenue circle, my lord, they are treated as a, my lord, urban area.
No, they will only treat.
I'll give details.
Where is that notification?
My lord.
Of 2016, they have only said that revenue circle cannot be the area. It has to be only the Tioga town.
Only basis of that letter, my lord, it is that our prayer was rejected. Only basis of that letter.
Where is the document of 2016?
That has not been produced to me, my lord. That is shown to by the deputy commissioner to the arbitrator, my lord.
Oh, go and find out. This is not there. As of now, your appeal is not maintainable. Okay. Mr. T.J. Mohanta, the learned counsel appearing, senior counsel appearing, and he asked for an adjournment for obtaining certain documents. List the matter on 10th of April.
My lord. Thank you.
Somebody may luckily admit.
Very difficult to get the my lord papers, my lord. Your lordship kindly see even RTI application, they have not been answered. I filed a writ petition before this honorable court to get the certified copy of the award, my lord. Then my lord, this honorable court asked me, then I'll.
Good for the lawyer.
They are
These
very-
activities are good for the
They
lawyer.
are zealous people, my lord, they are suffer a lot.
Yeah, they are suffered. Therefore, the lawyer should have, whoever was doing the matter should have, in the 34 applications should have properly advised these people. That you couldn't have filed this 34 in this manner. How can this be
My lord.
filed? All the people, all the villages come together, appoint one committee. Whether it is registered?
No, there is no date. That question, my very initial question I have asked them. But even then, my lord, one person is there, my lord, he's also an individual capacity, my lord, that will be reviewed.
Whether his land is there.
That
That is also not, no. Therefore, under 35(7), I can look into it. 34 also, one can't look into it. 34
But
also.
my lord, that the award is that is been rejected by my lord, the deputy, this appellate under 34, my lord, that is rejected on the ground that my lord, that because of the letter issued by the phone by the deputy commissioner, that this is urban. This is under Tiok Municipal Corporation, Tiok Town Corporation. That's why my lord award.
But therefore, the person aggrieved has to be who? Who are a party to the arbitration proceeding? Those person has to be.
We are also arbitration proceeding.
No. Kindly see section 3G5. A person or an entity aggrieved by that. How can all 7, 8 villages be aggrieved by one anything? Yes, you may be aggrieved. Every person has been paid.
My lord.
Yeah. No case. Luckily, I won't be sitting. Yes. What is this RFA business?
May I please, your lordship? Lordship, in this case, my learned friend has filed an application, lordship, for injunction. We have filed our objection today. Any day, lordship, tomorrow or day after, lordship.
Wait. First of all, what is this RFA?
My lord, my plaint was rejected.
Huh?
My plaint was rejected.
Why?
My lord, if your lordship takes up the order, my lord, the court has dealt.
Why should we go into injunction?
Exactly.
His application it was
Yes.
for ejection. Let's see the plaint. We dispose of the RFA matter.
My lord, I'll just quickly place the facts, my lord. The parties to the suit, my lord,
No, tell me what is the ground of rejection?
rejection ground, my lord, is.
Where's that order?
Page 22. Onwards, the reasoning starts.
22.
22, my lord, the reasoning starts.
What is the reason?
Reason, my lord, the trial court says that there is no chance that the plaintiff may succeed at the end of the trial.
Is that the ground?
Yes, my lord will see the order. The trial court has delved into merits, no evidence. It has held that I should have challenged some mutation orders, that I have no right as an occupancy tenant. My lord, this order cannot stand in my respectful submission.
Yes. What is this type of orders passed by courts?
Lordship, the
How
order is
can
there.
the court, the rejection of the claim on the basis of the plaint, whether it discloses the cause of action?
Okay, lordship,
Whether
then
it
issue
is
notice,
barred by
lordship,
law.
the parties has not appeared, lordship. Let them appear, lordship, all the parties. I am only one.
No. We'll settle that disorder. Unless it's this type
Lordship
of order.
can- Lordship, settle.
No, this type of orders.
Yes,
Let the
lordship.
suit
Lordship,
proceed.
settle.
Thank goodness, what is wrong? Show me, what is it here?
My lord, page 22 onwards, my lord, just the background, my lord. The father of
In the result, and what is therefore in the light of the man that the plaintiff who suffers from lack of cause of action.
Yes.
Lack of cause of action or does not disclose the
Does
cause of
not
action, the
disclose the
court doesn't know. In fact, the first judgment comes from our High Court in 1947, wherein the court, I think it was the division bench. Remember the judgment? Categorically says that
No, my lord, the fact, my lord, very quickly, my lord, their father and I were our step brothers. Our father was a recorded tenant. The suit is simple. I filed the suit to declare that I am also one of the inheritor, and therefore I also have a collective right. Now, on page 22 onwards,
There's a counterclaim filed
There's a counterclaim.
and the suit has been rejected and the counterclaim is proceeding. My goodness. Where is that application?
Let's see, 7-Eleven at
Yeah.
page 115.
When was this filed?
115.
When was this filed?
It was filed on the 30th of May 20.
And when was the written statement filed?
The statement was filed on 24th of July
24th of July
23.
and that application 7/11
May 20.
23. Prior to that.
Right. 30th of May 23.
Even in that judgment of Justice Krishna Iyer, in paragraph number 5 of the judgment 1977, Justice Krishna Iyer has said that whatever may be, you may reject the plain, you have to do so, have to be an active judge. But while doing so, you have to see strictly as to whether it falls within the ambit of Order 7 rule. You have the judgment?
I have the other judgment, Manoj, where it talks about that. I think.
That judgment categorically says that, paragraph 5, that strictly one has to look into, because this is a very drastic step for setting aside the entire civil litigation. So it has to confirm strictly within the ambit.
And if it falls, it becomes mandatory because of that.
Once it falls, then if he doesn't do so, it would be wrong. But if it does not, so therefore you can't go into any. How did the court go into all these things?
It's surprising that
All these things, how can it go? But that means the court have taken into account the written statement. The court have taken into account his application. He couldn't have gone into all these things. Except the plain, nothing else. and lack of cause of action. Yes, Mr. Sharma, anything?
Lordship must be allowed.
This is an application. This is an appeal filed against.
Lordship, I'll take it.
Filed against the rejection of claim, filed against the order dated, the judgment and decree dated, the order dated 2011-2023, passed in case number 536/2023, entitled suit number 211/2023, whereby the suit of the plaintiffs were rejected. Taking into account that rejection of a claim amounts to a decree, the present regular first appeal has been prepared. It is a right principle of law that while adjudicating an application under Order 7, Rule 11, the court is only required to look into the claim, look into the averments of the claim, only. The 6 cases when a claim can be rejected are where the plaintiff does not disclose a cause of action. Number 1. Number 2, where the reliefs claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so. Number 3, where the relief claimed is properly valued, but the plaintiff is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within the time to be fixed by the court, fails to do so. Number 4, where the suit appears from the statement in the plain to be barred by any law. Number 5, where it is not filed in duplicate, where the plaintiff is not filed in duplicate. Number 6, where the plaintiff fails to comply with the provisions of Rule 9 of Order 7. The proviso which have been added to the said provision categorically mandate that the time fixed by the court for correction of the valuation or supplying of the requisite stamp paper shall not be extended unless the court, for reasons to be recorded, is satisfied that the plaintiff was prevented by any cause of any exceptional nature for correcting the valuation or supplying the requisite stamp paper, as may be within the time fixed by the court, and that refusal to extend such time would cause grave injustice to the plaintiff. Therefore, here, Mr. Dekar, as regards E and F,
Yes.
The Supreme Court, I think in Salem Bar Association says that this is directly
This is directly in it's enlarged.
and time can be enlarged. That is Salem Bar Association.
Yeah.
2005.
And I'll check.
The 350 page. It is relevant to take note of that the conditions mentioned the of the above cases when a plane can be, it is relevant to take note that from the above cases when a plane could be rejected, enumerated, comma, the conditions at the condition number 2, 3, 5 and 6 permits the court to take appropriate steps to pass appropriate orders, thereby seeking compliance. However, as regards the condition number 1 and the condition number 4, that is, where the plane does not disclose a cause of action, or where the suit appears from the statement in the plaint to be barred by law, the court has no other option but to reject the plaint. This court also finds it very pertinent at this stage to observe that there is a fundamental difference between a suit a plaint does not disclosing a cause of action, and there is no cause of action in the suit. Inasmuch as when the court decides, inasmuch as in respect to the case falling within the ambit of the plaint does not disclose a cause of action, the court is required only to read the contents of the plaint and nothing more. And from there, the court has to come to an opinion that the plaint, on a meaningful reading, does not disclose a cause of action. On the other hand, when a suit, when the expression, the suit, there is no cause of action in the suit, it means that after the entire trial of the suit, wherein evidence, etc., are taken, the court comes to an opinion that the plaintiff have failed to make out a case for the purpose of being entitled to the reliefs as sought for. Next. The fourth condition pertains to the fourth condition wherein a plaint could be rejected is when, upon a reading of the plaint, it discloses and it is seen that the suit is barred by any law. The same has to be only on a perusal of the plaint and nothing more, inasmuch as anything else is being taken, the same would be not in the same. And nothing more. The reason, the rationale behind that is because of the use of the word where the suit appears from the statement of the plaintiff. Inverted commas. This court also finds it very relevant to observe that rejection of a plaint amounts to rejecting amounts to nipping at the bud a civil proceedings at the amounts to nipping at the bud a civil proceedings. And as such, the said being a drastic measure, it is the requirement of law that the same is that the conditions contained in Order 7, Rule 11 are strictly complied with. Let me come back. Remaining. Where is that other judge? What judgments you are getting?
But with your lordship, one is the Kamla versus where it was said that cause of action and bar by law are two separate things. Then we have T. Anantaram, the petitioner.
You got that 5, paragraph 5.
Paragraph 5, of course.
Yeah.
And then Dahi Ben, also, the last one. Dahi Ben, that of course.
You get me that judgment. That day I got it. 2 days back. Somebody's case it was. Mr. Sigdar produced that. I referred it on delay, on res judicata.
Open.
But Justice D.Y. Chandrasud.
Yes.
Get that judgment. Because there categorically says what are the 5 conditions.
Look on human the Pukaka. We put it to 1959. You are 1999. 99. The first is the Hanuman Das Totala judgment which the lordship had.
In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in Sri Hari Hanumandas Totala versus Hemant Vital, Kamath and others, reported in 2021 9 SCC 99, wherein the Supreme Court at paragraph 25 dealt with the aspect pertaining to Order 7, Rule 11D, and summarized that to reject the claim on the ground that the suit is barred by any law, comma, only the averments made in the plaint will have to be referred to. The Supreme Court further observed that the defense made by the defendant in the suit must not be considered while deciding the merits of the application. In the case of Dahi Behen versus Arvind Bhai Kalyanji Hansur Sali, bracket Bajra, dead to legal representatives and others, reported in 2027 SCC 366, the Supreme Court was dealt with the aspect pertaining to Order 7, Rule 11A.
(23.12) page 18, 23.12.
It was observed that the underlying object of Order 7, Rule 11A is that if in a suit, no cause of action is disclosed, or the suit is barred by limitation under Rule 11B, the court would not permit the plaintiff to unnecessarily protract the proceedings in the suit. In such a case, it would be necessary to put an end to the sham litigation so that further judicial time is not wasted.
(23.12).
This court also finds it very relevant to take note of the judgment of the Supreme Court in T. Arvindam Dhanam versus T. V. Satpal and another, reported in 1977, 4 SCC 467, wherein the Supreme Court at paragraph number 5 had duly observed that on a meaningful test, not formal test, reading of the plain, if it is manifestly vexatious and meritless, in a sense of not disclosing a clear right to sue, the court should exercise the power under Order 7, Rule 11, taking care to see, taking care to see that the grounds mentioned therein is fulfilled. In the backdrop of the above, let this court therefore take note of the facts involved as could be disclosed from the plaintiff. Who are you?
I'm the plaintiff.
Understood. Who are you in the plaintiff?
I am the
legal heir of whom?
Suryakanta Borua. And they are
from a perusal of the plain, it reveals that late Lakhikanta Borua and late Suryakanta Borua were occupying a plot of land measuring 2 bighas covered by dag number 937 new /827 old of KP Patta number 67 new /204 old, situated at Revenue Village Goral under Moza Ramsarani under Ajara Revenue Circle within the district of Kamrup Metro, Assam, as a tenant under one Drupad Chandra Borua. The said land have been specifically described in Schedule 8 of the plain. It has been further alleged in the plain that the name of late Lakshmikanta Borua and Suryakanta Borua appeared in the draft sheeter of 1957-64 as tenant, bracket riot, under Rupert Chandra Borua alias Rupert Borua. Subsequently, in the draft sheeter prepared in the year 1975-85, the name of Lakshmikanta Borua was only shown as a riot of the Schedule A land. And accordingly, a Khatian bearing Khatian number 74 was issued by the government in the name of Lakshmikanta Borua. The said Lakshmikanta Borua was unmarried. So after the death of the said, Lakshmikanta Borua, all the right, title, and interest and possession in respect to the Schedule A land as a right devolved upon his brother Suryakanta Borua. Late Suryakanta Borua during his lifetime married twice. His first wife was one Nani Borua, and his second wife was one Basanti Borua. The predecessor in interest of the defendant numbers 1 and 2
They are right to the first.
where the one of interest of the defendant number 1 and 2, that is late Obindra Borua, was the son of the daughter of late Suryakanta Borua through his first wife.
Yes. He was the son through the first wife. We are heirs through the second wife.
Understood. One, two, three, four will. 1, 2, 3, 4. The defendant numbers 1, 2, 3, 4 are the successor in interest of one late Obindra Borua, who was the son of the daughter of late Suryakanta Borua.
Son.
What?
Son.
Obindra Borua and Girish were sons of Srimati Putul Das. Defendant number 5 was
No,
the daughter of.
No, Manoj. Kopindra Borua and Girish Borua were the sons, and Putuli Das was the daughter.
The defendant numbers 1 to 4 were the successor in interest of late Obindra Borua, who was one of the sons of late Suryakanta Borua. The second son of late Suryakanta Borua expired, leaving behind his wife Lakshmi Borua, who is the defendant number 6, as the only successor in interest. The plaintiff number 1, 2, and 3 are the sons of plaintiff number 4 as the sons. The plaintiff number 1, 2, 3, and 4 are the successor in interest of late Suryakanta Borua to his second wife. Who is Kiran Borua?
Kiran Borua is the person who purchased the land from the landowner, Rupert.
Then,
My lord, then
and he transferred 1 bigha of land to former defendant numbers 7, 8, and 9. Who are they?
7, 8, and 9 are my lord purchasers who had bought the land from the the landowner. 7, 8, and 9 are
7 is the wife of Kiran
Kiran
Borua.
Borua. 8, 9, and 10 are sons of they are Suniti, Shanti, and Hirai.
They are all these 12 up till 12 are successor in interest of Kiran Borua.
Yes, yes.
In the meantime, it is also seen from the plane that in the meantime, that the landlord of late Suryakanta Borua and Lokikanta Borua, one Drupad Chandra Borua, transferred the entire Schedule A land to one Kiran Kumar Borua. The performer defendant number 7 to 12 are the successor in interest of late Kiran Kumar Borua. Late Kiran Kumar Borua during his lifetime allowed the name of late Obindra Borua to be mutated in respect of 1 bigha of the Schedule A land. Which have been more specifically described in Schedule B. It is the claim made in the plaint that the plaintiff numbers 1, 2, and 3 and the defendant numbers 1, 2, and 6 are residing over the said Schedule B land. Taking into account that steps were being taken by the defendants, the principal defendants, to alienate the said land and to oust the plaintiffs from the suit land. The suit was filed seeking decree for declaring joint right, title, and interest in possession of the plaintiffs over the Schedule B land along with the principal defendants as occupancy tenants. A decree for permanent injunction restraining the defendants, their men, agents, employees, servants from transferring and forcefully from transferring and or from forcefully dispossessing the plaintiffs from the Schedule B land and also from disturbing the peaceful possession of the plaintiff over the Schedule B land. In the backdrop of the above, let this court now take into account the impugned order dated 2011-2023. From a perusal of the impugned order, it reveals that the learned trial court first dealt with as to what is a cause of action. And opined that the cause of action appears to be the set of facts which justified for enforcement of a legal right for obtaining a relief in a lawsuit. It is on the basis of the said premises the learned trial court proceeded to decide the application under Order 7, Rule 11 for rejection of the claim. Which in the opinion of this court was totally misconceived. Thereupon, the learned trial court after taking into account the contents of the claim, so that the learned trial took into account the facts, the averments made in the claim, and opined that though the plaintiff claimed themselves as a riot, but they failed to plead anything about payment of rent to the landlord Kiran Borua. Since the settled provisions of law of Assam Temporarily Settled Area Tenancy Act obliges the tenant public right to pay rent to the landlord. The learned trial court further went ahead to find that the plaintiff also failed to plead specifically the manner of acquiring the right of occupancy tenant. And the mutation entries of the defendant number 1 to 4 over the suit Schedule B land was not challenged cleverly by the plaintiff with an intent to avoid the specific bar of presenting a suit before the civil court. The trial court further observed that if a right dies in the state, his legal heirs inherit the same. But if there is an inheritance of the property, there must be a plea on that, or record of right must be in the name of the plaintiff. However, the plaintiff failed to plead any specific plea regarding their right over the Schedule B land as occupancy tenant, and the plaintiff being the legal heirs of late Bakhanti Das, who is the second wife of late Suryakanta Borua, cannot inherit the suit land since they cannot claim the right of inheritance over the suit land after the land in dispute is mutated in the name of their stepbrother called late Gobindra Borua. It was further observed by the learned trial court that the plaintiff in the plaint failed to present any specific plea regarding violation of their legal right, which may give them the right of suing the defendant for enforcement of their legal right. And as such, the learned trial court drew a presumption against the plaintiff that their suit suffers from lack of cause of action, and the court does not find any justifiable reason upon which the matter may be put for trial, since there is no chance that a plaintiff may succeed at the end of the trial. It is on that basis the learned trial court came to an opinion that the suit of the plaintiff suffers from lack of cause of action, and for which the same is liable to be rejected. This court have, in the foregoing provision, in the previous segments of the instant judgment, have dealt with the concept, dealt with the provision of Order 7, Rule 11, and more particularly clauses A and B. This court have also dealt with the difference between a plaint does not disclose a cause of action and there being no cause of action for the suit. It is also a well-settled principle of law that as the application for rejection of the plaint has to be within the parameters as stipulated in or the various clauses of Order 7, Rule 11. And nothing more. The rejection of a plaint on the ground that at the end of the trial, the plaintiff would not succeed is completely foreign to the provisions of Order 7, Rule 11. A. Bracket. There is also nothing mentioned in the order that from a perusal of the plaint, perusal of the statements of the plaint, that the suit is barred by any law. So, taking into account that there has been that the learned trial court had committed a gross illegality in rejecting the plaint, this court therefore sets aside the order dated 20/11/2023. Passed in Mizze case number 536/2023. The plaintiff title suit number 211/2023 is restored to the file. Who has not appeared here, whom you have made party?
Lord, the application was filed by 1 and 2 who are represented.
1 to 6.
1 and 2. The application was filed only by 1 and 2.
Not by other.
Not by.
Who has filed the counterclaim?
Counterclaim also 1 and 2 only.
First as a decree bili koluna itu shouldn't be a decree. This appeal is taken up for disposal. At the admission stage. Taking into account that the plaintiff of a suit have been rejected. By the impugned order. No doubt. There are various parties in the instant application, instant appeal. But as the plaintiff was rejected at the behest of the defendant number 1 and 2, who are the respondent number 1 and 2 herein, and the said respondent number 1 and 2 is duly represented by the respondent, by the learned senior counsel, Mr. S. Sharma, the learned Mr. S. Sharma, this court have taken up the instant appeal for disposal at this stage. The parties before this court are directed to appear before the learned trial court on 1st of April.
28/3 is the date fixed for the counter.
Okay, on 28/3/2024. On the same date, the learned trial court shall further proceed with the suit. And if the defendant numbers 4, 3 to 12 have not appeared in the said suit or in the counterclaim, not appeared in the said suit or counterclaim, till the passing of the impugned order, when I have not appeared in the suit, the learned trial court shall issue fresh summons to the said defendants.
Deeply obliged.
What did it? Where is he?
My lord.
Yes, Mr. Sayawala.
My lord, this application was filed, my lord. What had happened? One succession application as well as one probate application is pending, my lord. Now the problem is that the property in the succession and the probate is somewhat similar. The reason being that if succession is allowed, the other side will be prejudiced. So our only contention was that until this final arguments, it is under final arguments, the succession be kept in abeyance. Only that is the prayer, madam. Because if
But what do
succession
you
is
say
allowed, the
about
other side will take
about the provision of section 387?
my lord 317.
What do you say about the provision of section 387?
My lord 387, what the learned quoted, my lord.
Huh?
That was on a different footing. That was on a different footing. The judgment that the learned trial court
No,
had
no. What do you say
indicated.
about section 387?
My lord, just a minute. 387.
Then nothing wrong, Mr. Saibal.
I'll leave it to your lordship. Only I was
think,
worried about
you see,
this fact.
Mr. Saibala, this case, if I dismiss it, it may portray wrongly upon you. I think better withdraw this application and fight it out there.
Well,
Better off.
well,
If you do, if I dismiss it, the court will say that look here, he has gone to the High Court and then has got a dismissal on the first day, and now he wants to fight out.
will withdraw. Well.
Mr. A.K. Saibala, the learned counsel appearing on behalf of the petitioner, submits that he would not like to press the proceedings, instant application, for which the instant application stands closed.
Deeply obliged.
Okay.
No, 49.
One is stay law. Mister, I will take your matter the last. Last item. Because you have spoiled a lot of time. Take it.
Tell you, Lord.
Wait. Stay matters.
55.
Arguing counsel Mr. Samaria, he is out of picture.
Don't worry, and take care.
Can I take tomorrow, my lord? Anyways, we have to submit our written submission of tomorrow. There is the direction.
Huh?
We have to submit our written submission of there is the direction.
Written submission, I have not heard it, and now you are saying about written submission.
Already, lordship is.
First and foremost, Mr. Counsel, in my entire judicial career as a judge, from 26th of October 2021, I have not taken a written submission from anyone. So under such circumstances, don't say about this written submission business. Written submission you give to courts who likes it. For me, whatever comes from you is a written submission of par excellence. Now submit. What is this case?
The case is that, my lord, suit was filed, my lord. Suit was filed for a decree of declaration, my lord. Along with an injunction petition, my lord. Petition injunction was granted by the learned court below. Thereafter, the respondents filed their appeal before the appellate tribunal, my lord. The appeal was before the appellate court, my lord. Then the appeal was allowed, setting aside that injunction order, my lord. Thereafter, we have filed this revision.
Your injunction order has been set aside.
Yes.
So now you have come under
section 115.
115. How is it maintainable?
We have come against the order of the appellate court, my lord.
So how is it maintainable?
That's why, lordship, we kindly give one only for the passport for the day, my lord. We have to keep tomorrow, my lord, to my senior legal argument. He will be having today evening.
Where's your file? Where's your file?
My lord, the brief is with him only.
We'll have it at 3:30.
He will arrive at 5.
You take this file. Take this file. Don't worry.
Can you tomorrow, my lord?
No, I'll hear only from you. Not even Mr. Samaria. If he comes tomorrow also, I'll only hear from you. So you have to do this. It's a simple matter. It's an injunction being granted, no, not granted. What is the big deal about it? How many years of practice you have?
4 years.
So, I'll help you out if you have a bad case. But if Mr. Samaria has a bad case, it goes to the dustbin.
Petition is not maintainable, my lord.
You are saying about 227? I'll
Yes.
convert it, don't worry. If he's arguing, I'll convert it. If Samaria is arguing, I'll dismiss it.
Let them file a fresh petition, my lord. Conversion, there is a.
Don't worry. This type of a thing, I'll convert it. Don't worry. This can be converted. There's a Supreme Court judgment. These things can be done. Conversion will be only IO has to be mentioned now. That is not the big deal. Because here the revision 227 and the revision will lie before this court. It can be very well converted. When unnecessarily asking them will be only violation to the environmental norms, taking into account so much of papers again he has filed. We'll take it up again today.
It should not be continued, my lord, because.
I'm taking up today.
Today, yes.
Today I'm taking up. I'm giving him some chance to read the file. But this thing would not happen if Mr. Samaria is appealed. Now I give you the doctrine of election. Yes, I give. Yes, next. Wait for some time.
46.
Yes, Mr. Bukasta.
My lord, Lordship, there is a stay order, notice was issued. And today it has come for.
What order you have challenged?
At page, my lord, 14.
Where is the impugn order?
Page 14. 17, page 17.
This order relates to so and so by the plaintiff for rejection and dismissal of the written statement counterclaim. The plaintiff said the defendant number 1 died as a result. Defendant number 1A was substituted as a but while defendant number 1 was alive, the suit proceeded ex parte against him. But when the defendant number 1A appeared, written statement counterclaim is filed by the which according to the plaintiff is barred by the provisions of law and liability. According to the plaintiff, the legal substitutor has no right to defend so and so. In so and so, the right to legally put up a defense is regulated in the defendant put up a defendant is appropriate character. Rightly so.
About the question arises, my lord.
First and foremost, Mr. Spookaster, the question, very simple question is this. You were the plaintiff? Why did you go for substitution when the defendant number 1 was ex parte? See order 22 rule 4. The moment it is not required to be substituted if the suit is proceeding ex parte. The moment you substitute it, the question arises, he has a right to do it. There the problem arises.
Yesterday evening, my lord, I was thinking about this particular question.
So rightly done.
But the
I
facts
can't help it.
Facts remains that, my lord, once suit is proceeded ex parte.
Understood. The moment you substitute it,
My lord.
the court would have obviously call for will ask them to file. He has a right to file.
My lord, kindly appreciate one thing. That question was dealt with by Delhi High Court. Same question, same factual situation. Once I step into shoes and suit has to be proceeded from the stage it was left out. If suit proceeded ex parte, they fail to, my lord, file WS. Therefore, whether by way of substitution can you alter or change the.
First of all, there was no requirement of substitution.
That's right.
If you have made the substitution, then in that case, because you see order 22 rule 4, it categorically
Yes,
says.
my lord,
Sub-rule 2, my lord. Sub-rule 2.
Yes, yes.
Then it is said.
Then, my lord, of course, my lord.
There's no way out.
Because of some conduct on my part, my lord, in approaching the court for substitution of the legal year, can that override the my lord?
Absolutely.
Can that override?
Yes, very well. It can be. Any party so made a party where is that order 41 year and shall cause the legal of the deceased to be a party and shall proceed with the suit. Any person so made a party in the event appropriate to his character here where within the time of limitation demand, where the parties demand, where is the provision? Where two or more. one or
Order
more
22, Rule 4, Sub Rule 2, my lord.
The right of the right to sue. Survive.
Any party, any person has made a party may make a defense appropriate to its character.
No. Another thing. There's another provision. There's no requirement of what do you call where
Number
within the
4.
time stipulated by so and so. No application. The court, whenever it thinks fit, may
Yes.
exempt
Yes.
the plaintiff from necessitating of substituting the legal heirs of any defendant who had failed to file written statement,
Right.
or who had filed it, having filed it, had failed to appear and contest the suit at the hearing and judgment. Now, the moment the substitution has been done,
Yes. Right accrued. But Roshi will appreciate one thing, my lord.
okay. Furthermore, how much time did we spend on this type of things?
Already the suit also, the plaintiff is also dismissed, my lord. And my lord, Delhi High Court says, my lord, it will amount to, my lord.
What happened? The plaintiff suit has been dismissed.
Yes.
What?
Whether it will
Dismissed?
amount to.
Yes, my lord.
Huh?
No. That was the wrong I have done, my lord. I must say, I should not have.
No. The problem arises not only you committing the wrong, the court, the moment the court exercised the discretion
Yes.
and allowed the substitution and called for filing of the written statement,
And I will
all the other orders got gone.
But that aspect was not considered, my lord.
When was the suit dismissed?
Judicial discretion can override the statutory provision.
That is
Once there is a position settled because of, my lord, non-filing of WS and suit proceeded ex parte and suit was fixed for evidence of the plaintiff.
After hardly I could go through the petition, my lord, which is not legible, my lord.
Petition?
Yes, my lord.
Where?
Orders, my lord. Each and every page of the order.
No.
My lord.
Where is the
my
order?
friend may not go through the copy of my petition.
Mine is also
Which
my
suit?
petition is also same like that.
Where? Which page?
You refer the page.
Yes, my lord. Page number 68 of my copy, my lord.
58.
68.
68.
Yes, my lord. Very poor, my lord. Not legible. Print quality is very low, my lord.
68.
Vacating the ex parte order
73, my lord.
finally came
That
up
was
for hearing on
provided
one
period.
basis of 20.
Very hardly I could go through it.
Page
68, 73, 73, 75, my lord.
on the petition.
Suit was
for the
dismissed,
section
it was
of the
subsequently
written
restored.
heard by this court and by
Page number 5.
Why are you saying that the plaintiff the suit has been dismissed?
Initially dismissed, my
Yes,
lord.
my lord. Subsequently, according to them, my lord, it is restored, my lord. It is not of my lord.
No, because obviously there was a stake.
Yes, my lord.
Otherwise, my lord, there would not have any question to, my lord, allow substitute.
Hello. The instant
My lord,
application.
my lord, for my personal, my lord, my lord, for my personal interest, my lord, I would like to refer one decision.
Oh, please.
Delhi High Court. The same situation, paragraph 4, it cannot alter the situation. Unless and until he is imputed as in personal capacity.
But in none of these cases,
My lord,
Order 22 Rule 44 was taken into consideration.
that's right. But the facts remain there, my lord. In that case also, legal errors was substituted.
Understood. But Order
Obviously,
22
my lord, otherwise,
Rule 44,
why is the question for him to?
they went into Order 22 Rule 42.
That part was, of course, my lord, not.
So, without taking that, how should we? Anyway.
But Lord should appreciate that he was also
Instant
brought on record
application.
as legal representative.
Mr.
Thereafter, he filed his
Professor,
application.
not only that, in the Delhi High Court case, the trial court had also rejected it. And the matter went into 27. And the court did not. Here the court allowed it. The matter is before it. I will maintain the same thing by not interfering.
Only Lordship is relying on, my lord, subsection 4.
It's not necessary. Because why it is, you see, the basic reason why I am saying it.
Yesterday, I have told him, my lord, there is
Why is it required, Mr. Professor, why is it required to substitute?
Obviously, my lord, in order to enable him to put his defense.
No.
To defend, my lord, to defend
No,
his-
not to put his defense. If you don't, otherwise it can very well go.
that's
Otherwise it can very well go. But the moment you substitute, you are passing a decree against him. Because therefore you see the rest of the line.
Right.
In Order 22 Rule 44, he said that if the court does not substitute, then the legal representative shall be bound. Kindly see the language.
Yes.
See, the last portion. Who has filed, and if it has failed to appear and the contest and judgment may in that such case be pronounced against the said defendant notwithstanding the death of such and shall have the same force and effect as if it has been pronounced before the death took place.
Yes.
So they will be bound. So now you want to bound the legal representative. And the court, while substituting in its own mind, did it? Didn't think about it.
My lord, I kindly appreciate, my lord, had he not been, my lord, allowed to file WS, what would have been the consequence? He will be, my lord, totally ousted from the court. He cannot even appear, he cannot even cross-examine, he cannot even adduce any evidence.
Absolutely.
And he will shall have a right only to point out that whatever evidence was adduced by the plaintiff not sufficient in terms of Order 20, Rule 4 and 5. Therefore, once you are allowing him to file WS, that means he was brought back into suit and to contest this suit. And that was also not taken into consideration, my lord, whether he was substituted earlier or subsequently he has filed the appeal. To file WS. Here also, my lord, it is the duty of the plaintiff to make an application to bring the legal heirs of the deceased defendant. But that doesn't mean that.
No, kindly see the language. The court, whenever it thinks fit,
yes,
may exempt the plaintiff from the necessity of substituting the legal representatives of any defendant who had failed to file a written statement or who have failed to appear and contest the suit at the hearing.
Right.
And the judgment may in such a case be pronounced against the said defendant, notwithstanding the death of such defendant, and shall have the same force and effect as if it had been pronounced before the death took place. Now the court exercises the power
right,
and permits the substitution.
But at the same time, court need to be more cautious about, or should have been
cautious, but the
should not be
question is the
oblivious.
plaintiff counsel was not cautious there.
My lord, Lordship kindly appreciate one thing, my lord. Once some privilege is given to the plaintiff and some discretion is given to the court should have taken care of that. Once a right accrued in favor of the plaintiff, I must not exercise my discretion. Court could have prevented me.
The plaintiff counsel who was there should have been more careful and told the court that you see, ex parte, why do you need to substitute? That was not done.
That was not right, man.
Chalo.
Even then, in an appropriate case, Lordship will decide.
In
this question.
an appropriate case, just for example, I'm telling you, that is why my order, I would not be deciding much on that. I would only say on 227, this court is not interfering. The reason why I'm saying is this: there might be a case where the suit has proceeded extremely, and now the court had made a mistake without overlooking this.
Exactly. That I want to say.
No. Then in that case, it's a different thing. But not in the case. Then I will again hear you on this.
Monday.
No, that case, if another case comes. I'm coming back after 5 minutes. Mr. Protester,
my lord,
the order is very clear.
My lord.
It is the defendant's written statement come counterclaim filed by the defendant number 1A.
My lord.
And I am only to
Defendant
look into as to whether the order passed on 3/10/2019 is wrong or right.
That's right, my lord. But if court proceed, my lord, taking into consideration that this is a joint WS for all the defendants.
That is not mentioned. Na? The defendant, it is clear. It is only 1A. Since the defense put by defendant number 1A is appropriate to the character of the deceased defendant, the prayer made by the plaintiff for rejection is not.
Only in respect of defendant number 1.
It is already there. You say, ask your trial court counsels to be, you advise them and not to repeat such mistakes. Now, this is an application under Article 2 to 7 of the Constitution, challenging the order dated 3/10/2019, passed in title suit number 157/2014, whereby the petition filed bearing number 5455/2018 for rejection of dismissal of the written statement come counterclaim filed by the defendant number 1 capital A was rejected. The record reveals that the plaintiffs herein had filed the suit being title suit number 157/2014. Seeking declaration of their right, title, and interest over the scheduled plots of land as described in the plaint, for confirmation of possession of the plaintiffs over the scheduled land, for permanent injunction, and in the alternative, if the plaintiffs are dispossessed during the pendency of the suit, for recovery of possession. The said suit, upon being filed, the defendants entered appearance on 29/5/2014. On 18/9/2014, taking into account that the written statement was not filed by the defendant, even after the expiry of 90 days, the issue of filing of the written statement by the defendants was closed. Thereupon, the suit proceeded. The defendant number 1 expired on 2/7/2016. Pursuant thereto, an application was filed Three applications were filed by the plaintiff. The first application pertained to condonation of delay of 54 days. The second application pertained to setting aside the abatement. And the third application pertains to substitution of the legal heirs. The learned trial court, by order dated 5/8/2017, condoned the delay, set aside the abatement, and substituted the legal heirs of the defendant number 1. Thereupon, Summons were issued by an order dated 18/9/2017. The defendant thereupon, the newly the substituted defendants, more particularly the defendant number 1, filed a written statement cum counterclaim on 13/2/2023. Huh? When? 13/2/2023.
No, 18.
13/2/2018.
13/6.
13/6. Thirteen to 2018. Immediately upon filing of the said written statement and counterclaim by the defendant number 1A, a petition was filed by the plaintiff
It would have been, my lord, 13/6, not 2. WS.
13/6. 13/6/2000. 13/6/2018. Filed a written statement cum counterclaim. The defendant number 1A filed a written statement cum counterclaim on 13/6/2018. Thereupon, after a passage of 6 months, on 17/12/2018, an application was filed by the plaintiff for rejection for dismissal of the written statement cum counterclaim filed by the defendant number 1A. The said petition was numbered as petition number 5455/18. To the said application, the defendant number 1A had filed a written statement and written objection. In pursuant thereto, subsequent thereto, after hearing the order dated 3/10/2019, which have been impugned in the instant proceedings, was passed. This court finds it very pertinent at this stage to observe that pursuant to the order passed for substitution of the legal representatives of the defendant number 1, on 11/5/2018, The defendant number 1A appeared and filed a petition bearing petition number 2366/2018, seeking time to file written statement. On this very day, the learned counsel, appearing on behalf of the plaintiffs, opposed the prayer for filing of the written statement by the defendant number 1A. And the learned trial court, upon considering the same, directed the defendant number 1 to file the written statement 1A, to file written statement
As well as for objection.
oblique,
As well as for objection by the plaintiff.
oblique objection. The record further reveals that on 13/6/2018, the defendant number 1A had filed a written statement cum counterclaim. The further orders passed by the learned trial court on 24/7/2018, 27/9/2018, shows that the service upon the defendant number 1 Roman 2 was not complete. It was only on 17/12/2018 that a petition bearing petition number 5455/2018 was filed by the plaintiffs. Pursuant thereto, on 3/10/2019, the impugned order was passed.
Defendant also filed objection against our.
And that I have said. Okay. This court had duly taken note of the provisions of Order 22, Rule 4, Order 22, Rule 4, which is the procedure stipulated in case of death of one of the several defendants or the sole defendant. In terms with sub Rule 2 of Rule 4 of Order 22, that any party so made up, any person so made a party may make any defense appropriate to his character as a legal representative of the deceased defendant. In terms of sub-rule 4 of Rule 4 of Order 22, the court, whenever it thinks fit, may exempt the plaintiff from the necessity of substituting the legal representatives of any defendant who have failed to file written statement or who, having filed it, have failed to appear and confess the suit at the hearing. And the judgment may, in such a case, be pronounced against the said defendant, notwithstanding the death of such defendant, and shall have the same force and effect as if it had been pronounced before death took place. Therefore, from the said sub-rule 4, the court could have, in the present facts, not substituted the legal representative of the defendant, number one. However, it was the defendant number one, a plaintiff, who had filed the application seeking condonation of delay, setting aside the abatement, as well as for substitution of the legal representatives. And after a detailed hearing, the learned court below, the learned trial court, by order dated 5/8/2017, permitted those three applications, thereby substituting the legal representatives of the defendant number one. Under such circumstances, in the opinion of this court, the court, in the opinion of this court, by operation of sub-rule 2 of Order 2022, Rule 4, the defendant number 1A, the substituted defendants, including the defendant number 1A, had the right to file, to take any defense appropriate to his character as the legal representatives of the deceased defendant. The learned counsel, Mr. A.K. Purkayastha, appearing on behalf of the petitioner, submitted a decision of the Delhi High Court in the case of Manju Party and others versus Rohit Party. Passed in CM bracket M number 1419/2007. The learned counsel submitted that in view of the law laid down by the Delhi High Court, had that merely because he is merely because the substituted person, legal representative, a substituted defendant is a legal representative of the deceased defendant, he does not get a new right to put the clock back and file the written statement as if the case had started afresh. This court, having taken note of the said judgment, finds it relevant to opine that the said judgment was rendered in a case where the trial court refused to grant the permission to the substituted legal representative, substituted defendants to file their written statement, and against which a proceedings under Article 2 to 7 of the Constitution was initiated. This court also finds it very pertinent to take note of that in the said judgment, the learned single judge of the Delhi High Court did not take into consideration the effect of sub-rule 4 of Rule 4 of Order 22 of the Code. And its correlation with Order 22, Rule 4.2, where in spite of the court could have proceeded without substituting the legal representative, the court have substituted the legal representative. This court have also taken note of the impugned order dated 3/10/2019, and is of the opinion that this is not a fit case for exercise of the supervisory jurisdiction of this court under Article 2 to 6 of the Constitution, more so when the discretion which has been exercised by the learned trial court does not shock the confidence, the conscience of this court. Considering the above, this court therefore dismisses the instant application. Dismissed. And now it is dismissed with cause also. Dismisses the instant application. This court further finds it relevant to take note of. Oh, you are the plaintiff, na? No. But it's relevant to take note of that by the order dated 5/6/2023, the further proceedings of title suit number 157/2014 was stayed. The stay order is vacated, and the parties herein are directed to appear before the learned trial court on 8/4/2023 for further.
2nd of May was 24.
What?
Court has fixed the matter on 2nd of May.
Why?
For my lord SCC.
Forget about the court doing
I
on
know.
on
On April.
8/4/2023, so that the trial court can further proceed with the matter in accordance with law.
8/4/24. Next date of April 8/4/2000.
Yeah, 8/4. I also said 8 without knowing that.
My lord. Lordship knows everything.
No. I didn't know. You said 2/5. He said 8/4 now. I on my guess said 8/4. Yes, what is this? Another case? Stay.
Lordship, here in this case, an application was filed under Order 13, Rule 10, calling from records from the other court, and that was rejected. And this order has been put to challenge before the novel court.
Where is your petition?
The application is at page number 12, annexure 1.
That prior to the institution of the suit, the defendant number 2 filed so and so against Uma Roy, who is the wife of so and so animal. The reported present petition plaintiff filed petition for proceeding in such defendant, and on reject of the statement plaintiff substantiate the fact that the statement of the object attack, the statement of the present suit came in for the therefore sequence of the fact the institution of the student for the purpose of cross-examination of the plaintiff at the court pursuant to- Then
And that has been rejected, Lordship, with the
rightly rejected. Was it on affidavit?
that was not on it.
Well, the order 13 will 10.
Yes. It's required to file with.
What are the requirements? Order 13 will 10 to.
It is there, Lord. The requirement is there. Every application made under this rule shall be supported by an affidavit.
Then
Requirement is there.
further.
Supported by an affidavit showing how the record is material to the suit in which the application is made, and the applicant cannot, without unreasonable delay or expense, obtain a duly authenticated copy of the record or of such portion thereof as the applicant requires, or that the production of the original is necessary for the purpose of. That part is there, Lord. Not on that, but the.
We do one thing. We don't interfere with this order. This order has been rightly passed. Then we give you, however, the liberty to file a proper application and the court shall consider without being influenced by this.
Yes.
And you have to say why you require that documents. That document, why is it required and what document you want? You want to show both the cases are same. So therefore, what you require? The plaint.
Yes.
Then why can't you produce the certified copy of the plaint? Then what else do you require?
Because in that particular suit, he is claiming his right over the land, and here in this case, he is saying that I am not the tenant. I purchased the property.
So what is
that
what?
thing, yes, Lord. That
The
thing
only
can-
the certified copy of the plaint.
Exactly, Lord.
Huh?
This will serve the purpose. The certified copy.
So you produce that.
Yes, yes.
So what remains in this? Withdraw.
Yes.
The learned counsel appearing on behalf of the petitioner submits that for the purpose of showing that the subject matter of title suit number 105/2015 was same with title suit number 61/2016. The production of a certified copy of the plaint in title suit number 103/2015 or such other pleadings so filed would be required. He therefore submits that he can procure those certified copies and produce before the court below, before the learned trial court. Under such circumstances, he submits that he would not like to press the instant writ petition. Taking into account the above, the instant writ petition stands closed on withdrawal. Full stop. It is made clear that the withdrawal of the instant petition shall not preclude the petitioner to produce the certified copy of the plaint and other pleadings in title suit number 103/2015 in title suit number 61/2016. Full stop. The interim order passed on 16/10/2023 is vacated. As the parties are duly represented, both they are directed to appear before the trial court on 8/4
Yes.
for further proceedings in the suit.
48.
Make visual.
Hmm.
It's plenty of for lordship. We filed a suit for recovery of area rent and eviction of the licensee lordship.
What is this CRPIO for?
Yes,
Which order?
order at 62, page 62.
Page
62. The defendant there filed two petitions to it. Petition number 368 and 369.
Hmm.
368 is regarding calling for NJ cases.
Hmm.
And 369 is regarding production of certain documents.
Hmm.
Then we filed the objection
Hmm.
on 25/5/23. That there was fixed for objection and objection hearing. Then we looked at the objection we have filed, and the other defendant also received the objection, then hearing is done. Then it was fixed for order. After certain days, this order has been passed. The first order lordship, he did not take into account anything, what we have stated in objection, what we have argued. Only on the basis of the schedule of the NJ case, this order, first petition has been disposed of.
Huh?
Yes.
What?
The first petition Lordship regarding NJ cases,
Hmm.
we file objection.
Hmm.
They received the objection on the same day, Lordship, hearing was took place.
Hmm.
So without considering the objection, without anything referring to our argument, only on the basis of that in their petition, they have given a schedule of the NJ case. On that basis, this first petition, 368 has been disposed of.
Hmm.
And second petition, it says that we did not file the objection at all. So since we did not file the objection, so second petition is also allowed.
Are you in possession of that document? Lease deed dated 1/12/1989.
Yes, we already submitted Lordship, in our evidence, the license.
Lease deed dated 1/12/1989.
Those documents we are having, Lordship, but
Tenancy agreement dated Iman, leave and license agreement. Yeah. Do you have it with you? Not with you now.
not.
Are you in possession?
We are having. Now,
Then why you are not giving?
no, that is not Lordship. So far as first part is the NJ cases, Lordship.
We'll come to NJ cases subsequently. First, you come to this. You have these documents.
We had the document,
The
but
court has asked you, why don't you produce it?
but Lordship, this thing has a thing is that objection we have taken.
What objection?
On that objection we have filed against that petition.
Under the written order 11 rule 14 application, you have the document, you produce it, because how will the plaintiff prove it? That is what. Now coming to the NJ cases, where are those NJ cases?
Now, Lordship, kindly see what they are plea in the written statement. For a moment, Lordship. At page 34, I'm showing the relevant portion of the Lordship, kindly see
Yes.
para 8. From bottom, Lordship, line about 14, Lordship, in the middle. Finally, started by the finally last word, 14th line.
Finally. On Iman, another
Finally,
legal
on
license.
Iman, another leave and license agreement was executed for elements marked at a monthly license fee of rupees so and so per month. And a photocopy of the agreement is given to the dependent number 1. And dependent number 1 used to pay monthly license fee regularly without fail. And before that, used to pay the monthly lease rent and thereafter monthly rent. As part is said, lease deed and tenancy agreement. That the plaintiff number 1 created 3 characters of the dependent number 1, such as lease, tenant, and licensee, in respect of same supremacy since 1989 till date, and the defendant number 1 performed duty in each and every character, and the defendant number 1 continued to carry out his business in the supremacy since 1989, and never handed over the possession of the premises.
No, let us come back to page 42. That even after repeated requests, the plaintiff had not received the monthly fee for the month of November 2000 and having no other alternative, the defendant deposited the same before the court to the Ms. NJ cases, Chalan number dated Iman, and defendant number 1 regularly deposited the same in the court in Ms. J case number so and so, and Iman. Now let us see this. Where is his application?
Application, Lordship, 44.
When was the suit filed?
Suit filed in 24/1/22.
24/1/22.
Yes, 2020. Their petition is at page 44.
So why don't you want this page 45 serial number 1 document? Why don't you want it?
Lordship,
It is wrong number. This is 21 or 22.
21.
Because this should have been 21.
No, Lordship, they did not.
But why he's asking for so many? Have you filed any application that during the pendency of the suit he has not made any payment?
Last payment he not made because it was till this one the license.
No, Mr. Deka. I'm asking you a specific question. You see, Sobha Vishwas judgment. during the pendency of the suit, he is required to pay. Isn't it? During the pendency of the suit, he is required to pay the rent.
Here, rent is not coming out because license fee got here.
So you say
there are
that it is a license.
License.
So NJ case has no relevance.
No relevancy. And he admitted Lordship in written statement. Earlier it was lease. After expiry of the lease, there was a tenancy agreement. After expiry of the tenancy agreement, there another lease agreement.
Did you file an objection?
Yes. Lordship kindly say, and what learned judges stated regarding
Where? This objection. Petition
objection
under order
at
11
page-
rule 14.
Page 51, Lordship.
Huh?
Page 51, our objection. If your Lordship see the objection, we have filed on 25/5/23 and copy received. We filed before the bench is done. Copy received on the same day and hearing took place. Now kindly see the note, Lordship, here. Seen judges, when we apply for the certified copy, office refused to give the certified copy. Then the
Copy received.
place the record before the learned judge.
25.
Learned judge passed the second impugn order, Lord.
25/5/2023. When was the order passed?
Order passed much later on, Lordship. After 2-3 dates, 7/9/23. Before that, there are 2-3 dates.
Then what happened? Seen petition number
One
with
DP. There is
remark. The admissibility of this
admissibility
petition
of
document in the question which is fixed for date mentioned on 4/11 Iman by the order. Yes, what is it?
now, Lordship, when this order was passed, we applied for the certified copy of this objection. Then they refused to give the objection copy, saying that it is not reflected in the order. Then Lordship, Siddhartha placed the record before the learned trial court, and trial court passed the order at page 65. And in view of the order, that note has been put in the office, the objection, and then only certified copy has been given.
Then what happened?
After receiving this Lordship, we have filed this application.
What do you want?
So far as these NJ cases are concerned, Lordship, this, in my respectful submission, is not relevant because of their admission itself. They are saying, even Lordship, in the entire written statement, they are referring to license fee.
Has the issues been framed?
Lordship,
Has the issues been framed?
issues has been framed.
What are the issues?
Issues are there, Lordship.
You are appearing.
And there are, and
I
there
for
is
the respondent, my lord. What happened, my lord? Two petitions were filed, 368 and 669. Their contention is that, my lord, without hearing their objection, though they have filed before the honorable court, this impugn order has been filed. And thereafter on 29/9, in last order, this matter confusion was, my lord, shut out. And then another date was fixed for hearing. So may I pray, my lord, these two petitions, after hearing the objection, my lord, they can be disposed of, my lord, by the learned trial. Because they have filed petition, they file objection, it is correct that because of some confusion, the this written objection was not placed before the court. And date was fixed also, 4/11/23, but in the meantime, they have filed it.
Where is that order?
Well, last order, page 67.
that interfering with the earlier order, he fixed for hearing a vague order is passed last plan. Therefore, under the both parties directed to make submission. So what submission will make? Already he passed the order. And body of the objection, he referred to admissibility of the objection.
So there is a stay.
Yes.
No. Is there any issue that is the issue of whether the defendant is a tenant or not?
Lordship, there are five issues. Mainly, whether the suit is maintainable in its present form, then whether the defendant is defaulter in payment of monthly license fee in respect of the scheduled shop, whether the plaintiff has bona fide requirement of these two premises. 4 is whether the plaintiff is entitled to.
Now tell me, Mr. Dekar, how do you bring the legal license agreement here? Legal license agreement concept is there in the Easement Act.
Yes.
Easement Act is not applicable in a stamp.
Yes.
How do you bring it?
But Lordship, the principle applies. Let's say there is a judgment by Honorable Justice N. Gogol, Lordship. The subsequent judgment para 10 is like it.
No, this judgment has no relevance here.
Principle applies to it, that is the and here the paragraph 10.
Here,
Paragraph,
Justice Shyam's order, what is that?
paragraph 10.
But whether the issue was there, whether the easement, the concept of leave and license agreement, because you see, Section 5 starts with a non-abstinent clause, notwithstanding anything contained in any other contract or law. How do you take care of Section 5? Read it. After Urban Area Rent Control Act.
No, that is not it. They are not the tenant. That is why that
That is why, whether they, whatever name you call, it's a different thing. You may have in many agreements to the effect. You may say that he is going to be evicted tomorrow. If he doesn't pay these 50 rupees, he will be evicted. But can you evict him? Because Section 5 categorically takes care of that.
if this comes under the landlord-tenant relationship, if there is there, then only that act will come. But here,
Whether it is a landlord tenant or not, whether first of all the leave and license concept comes from the Easement Act.
yes, that is there.
That is another. Secondly, the question is, notwithstanding anything, any person who is there with permission, whether Section 5 would not be applicable. And if 5 will be applicable, whether he can do it or not, or at best, let the trial court has to decide as to whether he is a tenant or not.
Trial court will decide, but here, Lord, it kindly see the order. He did not.
No, has he stated that he is not a tenant?
Yes, we have said, and they also say. No,
It is
they
stated.
did not say they are not the tenant, but they say that finally it is the lease and license agreement, and they are paying the license fee. It is it all along they are saying that they are paying the license fee. Then suddenly in that paragraph Lordship referred to, they says that we are depositing before the court. So at least we raised that issue before the trial court by way of objection.
But doesn't the trial court have to decide that? as to whether the deposit of the NJ cases or the rent is right or wrong.
If it
Once
is not-
that has to be done,
If it is not required, then unnecessarily it will be burdened following those documents and exhibiting those amounts. Because if that is the case, then
no,
they are-
only to that effect which he have mentioned in the written statement, nothing further. Therefore, I asked, did you take the plea of Sobha Biswas? The Sobha Biswas says that you have to file an additional pleadings, saying that during the pendency of the suit, he has not filed, because you filed the suit in 2021.
Yeah.
So any payment thereafter has become inconsequential if you have not taken the plea. So all other things are not necessary except which have been mentioned in the plain written statement.
that will be decided during the trial.
No.
So far as
Therefore, directing all the NJ record will be wrong.
that is what Lordship trial court has not considered.
If that is not your plea, you have not taken the plea of Sobha Biswas that during the pendency of the suit he has not paid, then the question of him rebutting there does not arise. And the consequential effect is there is no requirement for him to prove that during the pendency he have been paying.
So far as Lordship, after filing this claim, then only in the written statement they are saying that we are.
But when the trial court is going to hear the matter on 411, why don't you do the hearing?
For 411 Lordship, for what? There is no specification why the debt is fixed.
What you are submitting, whatever you are submitting, you submit there. The exactly words.
No, thing is that Lordship, whatever order is passed, now that court cannot so much to review or revise that order. Lordship set aside the order and demand back the matter before the trial court.
We do one thing, we set aside this order and say that the court shall proceed with the hearing as per its order dated so and so. But without setting aside, the court could not have done.
That is my point, Lordship, I have taken. Because this order, it said make submission on the next day. On what submission will make on next day?
So we set aside that earlier order
Yes.
only to the extent of NJ case, not the other. The other one is okay. You have other one you don't. You have those documents
Otherwise,
produced.
no difficulty except that thing that we did not file objection. That is thing, Lordship, because
Whether you have filed it or not, that is immaterial out there. We just observe it that has no relevance out there. But those documents are in your possession, you produce it. That is okay, but we are interfering in so far as this order pertaining to the
petition number
index,
368.
which the court shall again rehear
Yes.
after taking into account the objection which was filed on. The instant application has been filed challenging the orders dated 7/9/2023 and 29/9/2023 in title suit number 39/2022. From the facts enumerated, from a perusal of the materials on record, it reveals that the plaintiff herein had filed a suit seeking ejectment of the defendants, recovery of area license fee, realization of pendant light and future license fee as damages. To the said written suit, upon the said suit filed, the defendant jointly, the defendant number 1 and 3 had filed a written statement. In the written statement, more particularly at paragraph number
8 and 9 Lordship.
paragraph number 8 and 9,
Page 34.
paragraph 8,
Paragraph
8 and 9,
at page 34.
it has been the stand of the defendant, amongst others, that the defendants entered into a legal license, the plaintiffs entered into a legal license agreement with the defendant on 1/1/2021. And thereupon, the plaintiff have been duly, the defendants have been duly making the payment. Further to that, in paragraph number
9 of the
at paragraph number 25, it has also been mentioned that the plaintiff number 2 did not receive the monthly fee for the month of November 2021, for which the defendant number 1 started depositing the rent in the court in the form of NJ cases in exercise of the powers under, in terms with section 5(4) of the Assam Urban Area Rent Control Act 1972. In the context, in the above context, this court finds it relevant to take note of that there were 2 applications filed by the plaintiff defendants. One was a petition number 368 calling for the records of various NJ cases. Records of 14 NJ cases. And the other application was an application filed under Order 11 Rule 14, read with section 30 of the CPC for production of various documents. Both against both the petitions, the plaintiff filed objection on 25/5/2023, which is apparent. This is a certified copy.
Yes, sir. And yes, certified copy and that scan copy also given.
This is scan copy.
Down below.
Oh.
This is certified copy.
Where? And Excel 5 is the 5 and 6 are certified copies.
Yes, sir.
There's no certification.
That stamp is there, Lordship, it along with the other documents it was given. And Lordship, the court has also sent that scan copy. It is there in the another file, Lordship. Down below another file is there. Court has sent the scan copy.
Okay, it's there.
Same thing is there.
I filed written objection to both the petition number 368 and 369 on 25/5/2023. In the objection filed to the petition number 368, by the plaintiffs, it was specifically stated that when the defendant claimed that they are licensees, the provisions of the Assam Urban Area Rent Control Act 1972 has no relevance. And as such, the calling for the NJ cases, the applications sought for calling the NJ cases is nothing but an abuse of the process. Are irrelevant, unnecessary, and tend to prejudice and delay the fair trial of the suit. In respect to the objection filed to the petition number 369, it was mentioned
Verify.
No. In respect, in the objection filed to the petition number 369, the plaintiffs have also sought for rejection of the said application on the grounds stated therein. Pursuant thereto, The impugn order was passed on 7/9/2023. The said impugn order. Now, while passing the said impugn order dated 7/9/2023, the learned trial court directed the Seristadar to furnish those NJ case records to the court on or before the next date. And the defendant was directed to take steps. In respect to the petition filed under Order 11 Rule, in respect to the petition number 369, the learned trial court held that the plaintiff did not file any objection and accordingly allowed the said application, directing the plaintiff to produce the lease deed dated 1/12/1989, tenancy agreement dated 1/4/2012, and leave and license agreement dated 1/9/2017 on the next date. Thereupon, the plaintiff applied for a certified copy of the objection so filed. And when such when such application was filed, the learned trial court, by the order dated 29/9/2023, duly acknowledged that the objections were received on 25/5/2023, for which the matter was fixed for submission of the parties on 4/11/2023, when the instant matter 23. Thereupon, the petitioner approached this court by filing the instant proceeding. And this court, by an order dated 16/10/2023, state further proceedings of title suit number 39/2022 till the next day. This court have also taken note of that on 4/11/2023, this court have duly heard the learned counsel appearing on behalf of the parties and given an anxious consideration to their submissions. The order dated 7/9/2023, on the face of it, appears to have been passed in complete with complete non-application of mind, inasmuch as the learned trial court did not take into consideration the written objections which were duly filed. This court also finds the substance in the submission of Mr. J. Decker, the learned counsel appearing on behalf of the petitioner, to submit that when it is the specific case in the written statement filed by the defendant that there is a leave and license, they are enjoying the premises on the basis of a leave and license agreement, where the calling for the records of NJ cases which are done, which pertains to proceedings under Section 5(4) of the Assam Urban Area Rent Control Act 1972 has no relevance. This court have also taken note of that this very aspect of the matter was not taken into consideration by the learned trial court. Further to that, while disposing of the application, petition number 369, the learned trial court did not also take into consideration the objections so filed. Objections so filed. And on the other hand, had observed that the plaintiff did not file any objections. In the opinion of this court, the learned trial court ought to have been more careful. Be it as it may, this court have also put a specific pointed query upon Mr. J. Decker, the learned counsel appearing on behalf of the petitioner, as to whether the petitioners who are the plaintiffs are in possession of the lease deed dated 1/12/1989, tenancy agreement dated 1/4/2012, and leave and license agreement dated 1/9/2017. The learned counsel duly submitted that that the plaintiffs are in possession of those documents. Taking into account that the said documents have been duly mentioned by the plaintiff, by the defendants, in their written statement, this court, in exercise of the powers under Article 2 to 7 of the Constitution, is not inclined to interfere with the order dated 7/9/2023, insofar as the direction passed for production of the lease deed dated 1/12/1989, lease agreement dated 1/4/2012, and leave and license agreement dated 1/9/2017. The petitioners herein shall duly produce the same before the court. However, as regards the order passed in petition number 368 of the 2020, 368, the same has been done without taking into consideration the very vital aspect of the matter, which is the heart of the litigation. And as such, this court sets aside the order dated 7/9/2023 insofar as petition number 368 is concerned. This court have also taken note of that the learned trial court have fixed 4/11/2013 for submission on the petition number 368 and 369. While its order dated 29/9/2023. This court is of the opinion that the learned trial court is required to decide afresh the petition number 368 by taking into account the objections filed by the plaintiff. This court have also taken note of that by the order dated 16/10/2023, the further proceedings of title suit number 39/2022 have been stayed. The said order of stay is vacated. Taking into account that the parties are duly represented, this court fixes the matter on 8/4/2024 before the learned trial court for further hearing on the petition number 368. The records which have been produced before this court be forthwith returned by the registry to the court below, so that on that very date the matter could be taken up by the learned trial court.
Okay. That is, next date is on 3/6/20. Next date of the case is 3/6/20.
Not necessary. We'll have it on 8/4.
Yes.
Court has done it obviously because there is a stay. Yes, any more matters? Oh, that matter is there. We'll have it tomorrow. Itu kali matter. We'll have it tomorrow.
Tomorrow.
This is the matter tomorrow at 2 p.m. 2 p.m.
My lord, I have item number 37. I have filed an application for condonation of delay in filing FAO. That may kindly be taken up because it was an ex parte judgment and marriage has been dissolved, lordship. The lady is there with a small child and no maintenance is being paid to her. The delay is of 250 days. I've tried to explain the delay.
Will have to issue notice?
Yes, lordship will issue. I'll take steps.
Item number?
37.
37 of the IA cannot issue notice making it returnable by 4 weeks. 4 weeks?
Lordship will
Where is
kind-
the other side?
He's at Gurgaon, lordship.
Issue notice making it returnable by 29/4/2024.
Obliged, Lord.
The petitioner is directed the applicant is directed to take steps. This is an application for condonation of delay of so many days in
250
filing
days.
the application filing the accompanying appeal against the judgment and order dated, decree dated so and so and so on. Issue notice making it returnable on 29/4/2024. So the petitioner is directed to take steps by way of registered as well as deed.
Item 43 and 44, my lord, the early hearing application, my lordship had allowed, and
Mr. Ganguly,
I understand.
there's no other problem. Why I am going slow, you must understand one thing. I have been given by the registry only 2 stenographers. I have to go slow. I can't go fast because today I have already dictated, you must have seen, except 1-2 matters, all matters have been
That is, I
finished.
I pay for any.
So
date
under
convenient
such
to you.
circumstances, the problem arises is if I take it fast, it becomes difficult. These are the 2 persons. Yesterday's matters have to be typed out.
Look.
There is a requirement that it has to be done within 5 days. It's not possible.
Look.
What to do?
Not any date convenient to your lordship.
You kindly ask the Registrar General to give me more stenographers, then I'll give you more. Otherwise, I can't help.
So with this particular item 60,
Hmm.
substantial question of law where the appeal memo or the wrongly typed. May I?
Which one?
Item 16.
What happened?
The substantial questions of law are typed wrongly, typographical error.
You want to do a second appeal before me?
Lordship.
Everybody is running away from me. Everybody is not doing an order 43, 41 rule 11 application, and you want this court to do it.
I'm for a caveator.
Eh,
Caveator is also there, but
hello, we'll have it. When?
Before 20,
Anything?
I'll be going outside.
On 20?
may I put it?
You give a copy to him. He's a caveat, na?
I have already given.
Today,
Well, what are the substantial question of law? Show me. Have a meeting. Meeting.
Yeah, prepared the
39. Oh, don't worry. I can just take up this one. Was committed wrong in partly between the suit of the plaintiff reverses by AI with the plaintiff on the ground that it did not come to the court team. Whether the preliminary decree for partition over the ancestral
cases that project their plaintiff. They are plaintiff, lordship, their suit was dismissed, lordship.
Whether these were issues framed
Lordship.
as we got wrong description.
No, lordship.
Then
No issue was framed, lordship, but lordship only on the ground that she has already taken her share, lordship, from the inherited property. The London trial court said that the plaintiff did not come to the court with this lordship. It is admitted she in her cross also.
who is the plaintiff?
I am the plaintiff.
Ah.
The plaintiff has filed a suit for partition. The London lower court has dismissed the case. In the appeal, it was allowed. Because admittedly in paragraph number 11 and 15, they had admitted this is a property of Chandra Bora, and there are court shares. They are admitted about all this suit property.
Yeah.
It is a joint property.
That first appellate court decreed the suit except schedule C, lordship. First appellate court held that, lordship, that she already received some share in schedule C. She admitted, so schedule C we are not giving. Our ABC, lordship, partition of the property.
APT.
My case is that, lordship, when she received her share, lordship, whether her suit is maintainable for partition of her share.
No, not fair. On 2009, the plaintiff's father died. On 2008,
We'll have it on 2020.
Lordship. Item 16.
What does co-pattadas have to do?
they proceeded exporting the suit. The suit was proceeded exporting against them. And moreover,
No. What does co-pattadas have to do? This is
they are not necessary parties.
you are not asking for the partition of the patta.
Yes.
Are you?
No.
Partition of the pattas inherited.
They are not asking. He will be asking for partition of the properties of that person concerned. Then how does 4 come in? I think, should you do it? As of now, you don't have a case. Hello. We'll have it on 20. You sure?
Yes.
Yes, his matter will have it on Friday.